60s. He did the same thing in the courthouse. When he was arrested the next day, he made sure he sat
Okay,
on
we are back
the
live.
African-American side of the room. And I'm going to try to do this pretty neatly. There's another document here. I don't know if you can even read it. I need to blow it up a bit. I don't really
Control plus.
What's that?
Try Control plus. See what happens.
You want to help me, Gary? Because I can't do it. Anyway, right over here, it mentions that announcers in Fort Worth state that the rifle found on the 6th floor. Thank you. Announcers in Fort Worth state that the rifle found on the 6th floor was a British Model 303, and that the 3 shells found on the floor were British 303 shells. That goes again to the issue of Frazier's very logical fear that anybody owning an Enfield 303 in the 6th floor would be extremely nervous that afternoon after that. Then this document here is from Jerry Hill, and it's an affidavit again, and it states that in the 3rd paragraph right here, it states that when the pistol was given to me, this is the pistol from the theater, it was fully loaded, and one of the shells had a hammer mark on the primer. And that hammer mark was not found, again, by the FBI. Another document I have right here, this is the document that created the log for the Secret Service regarding the presidential car. And you can see up here that the first date on the first entry is the 23rd of November, '63, and it starts right around the 1 o'clock period. And then finally, I've got a clip of a video. This is from a mock trial that was done in 1986, and the questioner is criminal defense attorney Jerry Spence, and the person being questioned is Harold Norman, who was one of the men on the 5th floor. My recollection is he's the only one who ever was quoted as stating that he heard the shells fall and that they were directly over his head.
Well, he tried to get you to say, the FBI in this case, that you heard the shots from right above you, but you didn't say that, did you? You didn't say you heard the shots right above you, did you?
No, I said I heard the shots above me. I didn't say it directly. I just want to say I said the shots above me.
Yeah. They were trying to get you to say something different, weren't they?
Yes, sir.
And you resisted, didn't you? You didn't want to have words put in your mouth,
No,
did you?
sir.
And you don't want me or anybody else to put them in your mouth
sir.
in this hearing. Isn't that true?
Yes, sir.
Nothing further. So our next witness would be Brian Edwards, if you're available.
Your Honor, can I just make, we're not going to cross-examine Mr. Sipich, but I just would like to make a comment that I think it would be fair. Make a brief comment and then have the witness. Thank you. I think it's important to note, and fair to the presentation, that Mr. Simpich was not going to make this presentation. There was going to be a witness, but that witness is unavailable. And so they've presented what appears to be a closing and, in my opinion, based upon what I heard the content was, legal arguments with regard to potentially the exclusion of evidence. And I think that Bill made those points. And I think that all of those types of points would have all been made outside the presence of a jury and likely before any trial that would have been made. And so therefore, I just think it's only fair that the likelihood is pretty much everything you heard would have never been heard by a jury. It would have all occurred before with regard to the exclusion of evidence.
And Gus, I am going to instruct the jury accordingly before they're excused to deliberate their verdict in this case.
And that was really, thank you, Your Honor, I appreciate that. And I think that was just sort of, and because we're not closing in this case, I just thought that was a fair point.
And I would not disagree. I would only add that it would probably wind up up, many of these issues would go to the weight of the evidence. The evidence would be presented in many instances, and the jury would decide the weight. And that evidence would be heard by the jury.
Well, that's all I wanted to say, Your Honor. Thank you very much
For now.
for time. Well,
Let's have the witness.
I like for that. All right, Brian?
Good afternoon, sir.
Good afternoon, Your Honor.
You are still under the oath.
Yes, sir.
Mr. Brian Edwards, could you introduce yourself to the jury and to all of us?
Yes, my name is Brian Edwards. I am a former police officer in the city of Lawrence, Kansas. From 1978 to 2001, I was a patrol officer assigned to the Department Patrol Division. I was also a member of the crime scene search team as the senior photographer, and I was also a member of the counter assault team as a sniper for 11 years.
And could you state for the record your knowledge in police procedures?
For the last 22 years, or the 22 years I was a police officer, I was involved with many investigations, criminal investigations, collection and preservation of evidence, photography, crime scene photography and analysis.
And what's your training and background in the conduct of investigations?
Criminal investigations was part of the work of a police officer. I was also assigned to the Fraud and Forgery Division of the Sheriff's Department and a task force. Also I was on the major case squad for the metro area of Kansas City as the chief photographer for crime scene analysis and photography.
And can you state, once again as a summary, your background on the use of firearms and training thereof?
While I was on the department, I was also a range master and firearms instructor, and as I said before, I was a member of the counter assault team as a sniper for 11 years.
And in terms of chain of custody issues, you have a background in studying those issues as well as an officer, correct?
Yes, as part of my training in the police academy as a trainer, one of the areas of expertise that I was involved in, or as a training officer, was the use and proper identification and preservation and chain of evidence, tracking chain of evidence of any physical evidence collected at a scene.
And what are your observations as to how long strict standards have been maintained by law enforcement agencies around chain of custody?
Chain of custody issues have been in place since the times of Sherlock Holmes in the 1800s in Europe. They haven't changed anywhere as far as any procedural events. It's just a matter of keeping track. It's a simple matter of keeping track from the time of evidence has been located at a scene until it's collected, until it's presented in a court.
Can you think of any major changes in chain of custody procedure from the 1800s till now?
No.
And can you state to us what you think is the proper method of maintaining chain of custody?
Proper chain of custody requires a simple matter of tracking. Once an item has been identified as a piece of evidence, it's collected by an individual who fills out a standard form. Each department has their own forms. It's an evidentiary form. They indicate on that form by initials or case number or date or time where the item was located, who collected it, and who then retrieved, who was given that piece of evidence in the next chain.
Is inscribing the item itself like a shell? Is that the ideal method of doing it?
No.
What's the ideal method?
Placing it in a sealed envelope of some type of non-porous material that would not absorb fingerprints or oils. In this case, if it was a shell casing, it would be placed in a paper envelope of some kind.
Okay, let's see if I can do this right. Good. So, Brian, I would like to take you to the rifle evidence, if I may, for a moment. I wanted to first ask you what this picture here portrays.
Go down to your movie screen, and we'll show the whole screen. Down to your right.
Down to my right?
Yeah, right. Right there.
That's it?
This is a cover of the American Rifleman magazine from February 1963. This is, in fact, my magazine, actually.
Okay. And then, next in order, we're looking at a series of 3 photos. This is one big page, then this is a blow-up from that page, and then the third is a coupon. First, let's go to this larger item. And what does it portray?
This is an advertisement for Klein's Sporting Goods in that February 1963 American Rifleman magazine, advertising a variety of firearms that are available through Klein's Sporting Goods store in Chicago, Illinois. This is the blow-up of that advertisement, specifically the Mannlicher Carcano carbine model C20 T750. It's a 36-inch model carbine, military-grade, Italian-made rifle.
Did it come with a scope?
According to this advertisement, the carbine with brand-new, good-quality 4-power scope is an extra $7, basically, if you ordered it from Klein's department store.
And a clip would come with that scope, correct?
No, I believe you would have to pay extra for that also.
It says here 6.5 military ammo with free 6-shot clip. Okay, I got it.
What's the $7.50?
$7.50 extra for the clip and 108 rounds of ammunition.
Okay, so this is again for a 36-inch rifle, and the mounts in this picture are mounted on the bottom, correct?
Yes.
All right. Now, we're looking at a 3-part blank post office box application, and the entire item is blank. There's an exhibit mark on it, nothing more. But there's a regulation that you wrote down next to it. And part 3 is the bottom portion, correct?
Yes.
And part 3 is to identify persons other than the applicant, correct?
Yes.
And if persons other than the applicant are going to receive mail there, you've got to retain this application for 2 years after the box is closed, correct?
According to postal regulations, yes.
So that should have been kept open until about 1965 then, correct?
Yes. That card should have been kept.
And it wasn't kept, was it?
No, sir, it was not.
Then we're looking at an application here. There's a signature there. Whose signature is it, for the record?
The signature is Lee H. Oswald.
Any mention of Alex Hidell?
Not on that form, no.
Now, there is Alec Hidell, or A. Hidell, to be precise, on 2 items here. One is a money order, correct?
Yes.
You're familiar with that money order?
I am.
And there's also a application filled out with A. Hidell's name on it, correct?
That is that's the coupon from the American Rifleman magazine.
All right, for that very particular item with all those numbers spelled out, correct?
Yes.
Okay. Next, I'm going to turn to the order blank, which again states this information with a serial number of C2766, correct?
Yes.
And it shows the order was actually shipped, correct?
Yes. Klein's shipped the item ordered.
Right, but is there any document showing that it was delivered to the Dallas Post Office?
No.
Any item showing that Mr. Oswald was notified that Mr. Hidell was trying to use his box?
Not that I have ever seen.
Or that Mr. Hidell or Mr. Oswald or anyone picked up anything from the post office?
That's correct.
Now, let's turn to the City of Dallas Police Department. This is an invoice from 4 days after the assassination, and it's got, again, a rifle with a C2766 serial number, correct?
Yes.
Now, let me ask you, We're looking at here, item from Mr. Frazier's testimony.
Yes, from the Warren Commission testimony.
Right, and it summarizes some information. What information is that?
They asked him if he had measured the length of the rifle, and he indicated that he had. It's 40.2 inches, and it weighs 8 pounds.
Very good. And then another individual from a sporting goods store was also giving a statement to FBI under oath, correct?
Yes.
Same finding, 40 inches?
Yes, sir.
Okay. Now, let's move on. We're looking again at the February 63 photo of the rifle, and the arrows point to what?
The arrows indicate that the weapon was shipped or ordered that had two clips on the bottom to allow for a strap to be attached to the rifle.
Now, this is Lieutenant Day leaving the book depository about an hour and a half after the assassination with a rifle, correct?
Yes.
And we've got a close-up in this next frame. Can you show us what these arrows portray?
The arrows indicate that the strap was attached to the left side, not the bottom, but the left side of the stock of that rifle that was being carried out of the Texas School Book Depository.
Do you draw any conclusions from that?
My conclusion is it's not the rifle that was ordered through Klein's department store.
Let me show you a backyard photo of Oswald, focusing for the moment strictly on the rifle. What do these arrows point to and for what?
The arrows indicate, or the arrow indicates the front mount, bottom swivel on the gun itself. That's where the strap would be attached, is on the bottom swivel. Okay,
so this photo portrays a rifle that is different from the rifle that was in evidence with the City of Dallas?
This is different than what we saw Lieutenant Day carrying out of the book depository with side strap mounts. This is the bottom strap.
Okay, now this is the rifle in evidence, correct?
Yes, National Archives, Washington, D.C.
All right, and this is a close-up of the mount right there, correct?
Yes, sir, that's the rear stock mount.
All right, now is it easy to swap out a bottom mount for a side mount? Do you have to machine it in any way?
Well, it'd have to be machined, yes. You'd have to have the brass, you'd have to have the ring to go around the stock to have a mount on the bottom, yes.
Do you see any indications that was done?
Not in this photograph.
For this photograph?
No, sir.
For this photograph shows the other side, correct?
Yes.
With no mounts?
Yes.
All right, and now we're looking at a clip for Mannlicher Carcano, and the significance of this clip is what?
This is the clip in evidence in the National Archives that, according to the Dallas Police, they found at some time associated with the rifle.
Is there any evidence you know of that it was jammed with the rifle?
That the clip was jammed?
Right.
No, I do not.
If you look at the Day photograph, do you see any indication of the clip there?
It's not clear enough to determine what that is.
And do you have yourself, Mannlicher, that you can display for us?
I do.
Could you do it at this time?
Sure.
With the understanding no bullets of any kind are going to go inside this weapon.
The court is going to ask the witness, because you are a current or former police officer?
Former, sir.
Former police officer. I'm going to ask you to clear the weapon off to the side first and then bring the weapon out into the open.
This is a safe weapon. There is no firing ability to it. You have to bolt. So this is basically a dead weapon.
The record will reflect the weapon has been cleared.
Yes, sir. This is as close as I could get to a duplicate to the Mannlicher Carcano in evidence, except obviously mine has the bottom strap. Side strap mount is what's in the archives. The scope is a 4x18 coated Japanese-made scope. It's similar to the rifle in evidence. It's a 6.5 millimeter Italian-made carbine, bolt action, which requires a manual operation of a bolt to eject and load a new round each time. Yes, I'm sorry. I don't know if I can do that both at the same time.
Thank you.
Thanks. The rifle works as a manually operated long rifle, or short rifle, but in order for this weapon to be fireable, it has to be loaded with a clip of 6 bullets. And I have, Your Honor, I have a clip that I would just like to show, if it's all right.
You make show the clip. Are you going to show it loaded or unloaded?
This is a fully loaded 6.5 millimeter clip for the Mannlicher Carcano. And how this works is this clip, it's not a stripper clip, it's a clip. It's called an in-block clip, which means it's an integral part of the weapon. It has to be with that clip to allow a person to use it in a rapid fire sequence. Without that clip, whoever would be firing the weapon would have to load it manually, load each bullet, eject it, load each bullet, eject it, load each bullet. With the advance of the Mannlicher, it was the actual folks that made this clip, it goes into the top of the firing chamber from top down, and there is a following arm underneath that you cannot see. It's underneath the trigger guard. And it pushes the bottom shell up into the next firing position. So as the bolt is operated, as the bolt is closed, the first round is loaded. Once the bullet has been fired, and I'm going to, Your Honor, if it's all right, I'm going to pull the trigger. There's no rounds in it, just to make sure.
You're going to dry fire the weapon.
Okay, thank you. So the first round is loaded if that clip was inserted. So you've got 6 bullets to fire. You pull the trigger. You operate the bolt. The empty shell goes out to the right at some distance, depending on how hard you pull the bolt. The next round is ready to be fired into the firing chamber, but you have to load the bolt. You have to lock it down. Now it's ready to fire again. So the sequence is 1, 2, 3. The last bullet was in the chamber when the Dallas police officers found it. So it was loaded, ready to shoot again.
It takes a few seconds to do that 3 times, does it not?
2.3 seconds between each firing sequence. The minimum, that was the FBI's estimate. That's without aiming. You have to aim to find your target again through that scope, which is not a good quality scope at all.
And your understanding of how quickly those 3 shots occurred?
According to the Zapruder film, it was less than 7 seconds.
All right. And the clip, after it is, the last bullet is chambered, what happens to the clip?
It's designed, the weapon is designed that after that last round is loaded, not fired, but loaded, it is by gravity will fall through the open slot in the firing chamber and the trigger guard.
Let the judge know that you're...
Judge, I'm taking the shells out of the
Thank you.
shell of the clip.
And the jury thanks you.
As you can see, there's only there's an open slot, and that's the slot that will allow the clip to fall through the firing chamber. And the idea is, since it's open on the bottom, once that last round is loaded, it should fall through. Okay, it should fall through.
Yeah, that's not right. Push the button.
You can't.
It should fall through. Now, I have not fired this rifle, and I probably never will, but there are times when it won't come through even when you're dry firing because of the soft metal of the brass is allowed, it has a lot of play in it. So, but the idea is it will fall.
No matter how you handle that weapon, I want you to keep the weapon pointed in a neutral direction, please.
As you see, that it did fall out with some pressure, but manually it should fall out automatically. That tells the shooter you're out of bullets.
And would you use this rifle yourself?
No, it's not reliable. I don't trust it. I would never fire it.
Is it, now, I'm going to ask you to put it away before I get nervous. And I used to teach rifle. But it's nice to see those things in their right place.
I was going to ask you these They do fit like.
Okay, Brian Edwards, I wanted to ask you if you could identify this scope for us.
Yes, this is an exact replica of the same scope that's in evidence in the National Archives, 4x18 coated. Coated means it's got a plastic film over the glass. And the 4x18, 4 means 4 power, that's the 4 magnification, and 18 is the 18 millimeters, the size of the rectal objective lens.
Okay, so you've included here a document from a researcher named Mr. Armstrong to Mr. Westra, former employee at Klein's. Can you summarize what this document portrays?
Mr. Armstrong asked the former gunsmith of Klein's if he'd ever mounted a scope on a 40.2-inch rifle, and he said no. That Klein's did not sell a package of 40 of the 36-inch model with a scope attached.
And then there's also an interview with a former gunsmith for Klein's. And was it pretty much the same response?
Yes.
We've looked at the clip. And then can you identify these 2 objects for us?
On the left is a 6.5 millimeter Mannlicher Carcano bullet or projectile. On the right is a 6.5 millimeter casing for that same bullet.
And so the casing goes over the bullet, correct?
The bullet goes inside the casing, yes.
Thank you. Then we've got some photos of a testing of this weapon at the evaluation branch of the U.S. Army. Can you summarize what Mr. Simmons' finding was?
Mr. Simmons, the chief of the Infantry Weapons Department of the United States Army, was asked during his Warren Commission testimony, did you have a chance to have your shooter, your practitioners, work the bolt, dry fire it basically? And his response was, no, we were afraid, we didn't want him to do that because we were afraid it would break the firing pin.
Any reason the firing pin was so fragile, or is it simply your understanding of the way the weapon was made?
I don't understand why it was their fear of it breaking all of a sudden.
And any difficulties in sighting the weapon in?
Yes, according to his testimony, they asked him if the shooters, the practitioners, people participating in this test firing, had any problems with sighting the target with the scope, and they basically all said that the scope was not aligned to the barrel.
And so they use any object to try to help them sight it in?
They did. They installed metal semicircular shims, they called them, underneath the barrel, between the stock and the barrel, to raise the barrel up to be in line with the scope.
And these are the shims in question right here?
Yes.
And what are we looking at with this next item?
This is a test firing. This is a document that's in the Warren Commission exhibits showing the test firing at 100 yards. As you can see, the black piece of tape is where their aiming point was, and the 3 shots were high and right, even after installing the shims.
Now, what was the average distance from the 6th floor window to the street below?
Before you ask that question, the court would like to ask the witness a question, if I may.
Please.
Would you please explain to the jurors and the member of the audience what barrel sighting is in terms of, and zeroing in a scope for a particular weapon?
Yes, sir. Scoping in a rifle basically is a shooter's slang for making sure the alignment of the barrel is in the same trajectory or the same point of where your scope is. A cold bore shot is what I was trained to shoot. Obviously, on a call out, if we had to take action, we wouldn't have time to go to the range and sight our rifle and make sure it was okay. So the idea was that prior to some event, you would sight the rifle in. You would look at a spot, usually a target with a crosshair, fire around, and if it was high, right, left, low, wrong, whatever, you would simply adjust your scope so that your scope is looking where your bullet went. Then you would readjust your rifle, point at that same aiming point, and you should be closer than you were with the first shot. So I guess what my training was that we could fire a cold bore rifle shot, and in 2 rounds, we would have it scoped into the spot where we're aiming. Does that answer your question, Judge?
Yes, sir.
Yes,
Thank you.
thank you.
Well, let me turn to the next slide, if I may, Mr. Edwards. What did Mr. Simmons state about difficulty sighting the weapon in?
Said they couldn't use the scope as it was located as in evidence, and they also tried to use the iron sights that were built on the gun. They basically, the way I read this is they couldn't sight the rifle in either with the scope or the rifle iron sights.
What's your opinion of the scope in terms of quality?
1 to 5 is 5 being the worst. This is a 7.
So you preferred the sights?
I'm sorry?
Would you rather use the sights than the scope? Is that what you're saying?
I would rather use the iron sights. That would be more reliable, yes. And if I could, Your Honor, I would just explain the 4x18 that you see imprinted on that scope means that 18 is the diameter, the millimeters of that objective lens, the one that the light comes in that you could see. The bigger the number, the better, the more light you're going to let in. On an 18 millimeter scope, such as the one that was in evidence, you cannot put your face up next to the scope because you'll be blocking the light. And I've probably fired 20,000 rounds in my career. This is not a scope I would ever pick to be able to hit a target unless it's 20 feet from me, then I could probably hit it. But using the scope for this would not be the objective.
Well, that leads me to that question from before. How far is your recollection from the 6th floor to the street?
I remember 187 feet was the fatal shot from the book depository.
On a diagonal?
Yes, on a diagonal on a declination of the roadway, yes, sir. 270.
Well, everybody's got, depends where you're standing, but I just wanted a rough estimate. So,
If I could just throw this in, the hardest shot for a sniper is from high to low, because you've got 12 different factors to consider. Level flat trajectory is the easiest because you don't have as much to worry about, but from high to low is very, very difficult. Whenever I went to a scene, I always looked for a position where I was almost on the flat trajectory with the target, because there's less calculations and I'm not that smart.
so what kind of test run did Mr. Simmons use with this rifle?
They used according to his testimony, excuse me, they used a stationary target platform at an elevation of 30 feet off the ground.
Does this accurately portray the site we're talking about?
Yes, this is the actual firing position that they built at Aberdeen Training Grounds.
And we're looking at the book depository. Did you draw in the arrow for 30 feet?
I did.
All right, now let's look at the serial number of the Carcano. Is that the serial number we see here in bright yellow?
Yes, I drew that square around the serial number so that it could be seen by the jury.
And then we're looking at another version of the same rifle, correct?
Yes, that's a close-up of the serial number on the Mannlicher Carcano in evidence.
And what's your observation regarding this number?
That last number is misaligned.
And can you explain it?
I cannot.
How is that number applied to the rifle, do you know?
This is a cold-rolled steel barrel, and it goes through a manufacturing process through a mill of some type of machinery shop or a plant of some sort, and each barrel is stamped with a multi-ton press to get that number impressed into that cold-rolled piece of steel. I'm assuming that the next barrel coming through that press would have been 2767. This is not something that's done by hand. It would take too long. Mass production that wouldn't be the term you would use. So there's something wrong. I see something wrong with that last number.
All right, now there's a letter from Lee Rankin at the Warren Commission to J. Edgar Hoover about the question of the serial number. Can you summarize what it is?
Basically, he said that multi-factories in Italy were making the same rifle, and no checks or balances were placed on any of the serial numbers. So in other words, they could have used the same serial number over and over and over again.
And then there was an interview by the FBI with an employee with a sporting goods store in Canada. And was his statement pretty much the same?
Same thing.
Okay, so let's move on to the, not that one, the rifle, I'd like to find the rifle shells.
I think it was the second one.
I thought it was too, but I'm not seeing it here. I'm seeing that.
That's it.
All right, here we go. So can you identify the gentleman we're looking at here?
This is Detective Eugene Boone with the Dallas County Sheriff's Department.
He claimed he found the sniper's nest, correct?
Yes, he said he was the first one to get to that location and identified it as a sniper's nest.
All right, and can you summarize what his testimony was regarding Captain Fritz's activities when he came to the scene?
His testimony was that when he first came to the scene, the southeast corner of the 6th floor, he recognized it as a possible sniper's position, saw 3 shell casings on the floor. Prior to moving or touching any of those items, Captain Fritz of the sheriff of the Dallas County Homicide Unit arrived. According to his testimony, he picked up those 3 shells prior to anybody taking pictures or measuring or indicating what they were, and then threw them back down on the ground, and that's the photograph that we see here.
This is the head of homicide.
The head of homicide, yes. 37 years.
All right, now we're talking about a different gentleman in this next slide. This gentleman, Lieutenant Day, was the head of the crime scene bureau, it says here. Crime bureau, I believe, in general.
Yes.
And can you summarize his testimony?
He basically said that we didn't move anything until we took pictures.
And so this is a little chart that you made, correct?
It is.
And next in order, did Fritz admit moving the cartridges?
Did he admit to it?
Right.
No.
He denied it, didn't he?
Yes.
Now we're looking at shells again in these next photos, and this portrays again the crime scene itself.
This is
alleged crime scene.
Yes, this is one of the many photographs taken of the alleged sniper's nest in the 6th floor window.
And those photos were taken immediately after discovery, correct? Did you understand it?
As far as I was told, as far as what I've read, yes.
All right. Blow it up. Thank you. Next in order. Now we got the 3 shell casings, if you can identify them.
Yes, these are the 3 shell casings that were reported to have been recovered from the 6th floor southeast corner window of the Texas School Book Depository.
And one of them has a dented lip, correct?
Yes.
And the next slide here, can you summarize what Day claimed his activities were?
Lieutenant Day of the crime scene unit testified that he picked up the shell casings and placed them in an envelope, I presume an evidence envelope, and gave them to another detective, and that's the last he saw of them.
Now, the next slide here states that he placed initials on them at a particular time. Can you tell us what that was?
According to his testimony to the Warren Commission, he did not see that envelope or the shell casings until 10 o'clock that same night.
And was the envelope open or closed?
He testified that the envelope, when he received it, was open.
And Detective Sims had the shells for at least some period of time prior to 10 o'clock, correct?
Yes.
Then here's Detective Sims, and can you summarize what he testified to?
Detective Sims doesn't remember during his testimony who or when the shells were given to him at all.
And he doesn't know about the possession of the envelope where the shells were either.
That's correct.
Okay. And this is the envelope in question. Can you see anything that's helpful in that envelope?
What I can make out of that is Lieutenant Day's signature, and there is some cursive writing at the top. I can make out that it said 3 shells found underneath the window, and the rest of it is almost unlegible.
All right. Let's move on to the paper bag. Again, these arrows point to the 6th floor alleged crime scene.
Yes.
And to the alleged sniper's nest.
Yes.
Going back to the sniper's nest, we're looking at the flooring. Do you see a paper bag in that photo?
No, sir, I do not.
Would you pull it up again for me? Yeah, I didn't want to guess it. Thank you. Then, no picture of the paper bag here either.
No.
And then I'm going to show you this one. Who prepared this dotted line of the paper bag?
My information was that during or prior to Detective Studebaker, who was the crime scene photographer at that time, he was asked by the Federal Bureau of Investigation to indicate on this photograph where the approximate location of this paper bag was, and that's what he did. He drew on the photograph. Those are his dotted lines.
And Detective Montgomery claimed that he discovered it, correct?
Yes.
Did he know any details about how he discovered it?
No.
He didn't know where it was located?
No.
He didn't know who touched it first?
No.
Or if the bag had been moved prior to photographs?
No.
Then Lieutenant Day weighed in at some point on possession as well, didn't he?
Yes.
He claimed that he discovered the paper bag?
He did.
And he claimed that he had written on the bag before releasing it, correct?
That's what he testified to.
And again, this is Montgomery carrying the bag. And then finally, there's some prints allegedly on the bag. And what was Day's testimony as to finding prints on the bag or not?
According to his testimony, he found no legible prints or usable prints on that paper bag.
Did the FBI find prints?
According to the FBI, they found a usable print after it had been shipped to Washington along with a lot of other evidence, and the FBI found a print.
All right. Now, there's one memo from the 30th of November stating that the paper was examined by the lab, and what was their finding in this report?
The paper bag was constructed of the same material as available in the Texas School Book Depository's first floor shipping department. And according to this document, it had the same characteristics as the paper bag stock in the book depository shipping department.
Now, we found another memo by the same man, allegedly on the same day, and it's almost the same, isn't it, Craig?
Almost identical.
All right, what's the difference?
The word "not" is in there.
Not what?
Not identical.
Not identical with the paper bag gun case
Yes,
found at the scene of the shooting?
yes.
Now, there was latent prints found on the boxes or not?
There, according to Lieutenant Day, he lifted a partial palm print off of the top section of a box in the sniper's nest.
Does that surprise you?
I'm sorry?
Does that surprise you that he found such an item?
No.
Why not?
Lee Oswald worked in the building. He had access to all the floors. That was his job. He worked there since October.
All right, let's go through the Tippett shooting really quickly. This is a diagram of the shooting scene, correct?
This is a Dallas County plat map of the Tippett scene, the 10th and Patton.
Okay. And then we're looking at the crime scene for where the officer was shot, correct?
Yes.
And that's where the two men were standing?
That's a reenactment that the Warren Commission did to simulate the position of the shooter and the officer at the time.
And that is a scene of where the shooting allegedly took place, correct?
Yes, that is Officer Tippett's blood.
Now, there's a long chain of custody, chain of evidence here regarding two .38 shell casings from the crime scene.
Yes.
And apparently, shell casings were dropped on the scene. Can you describe how they were dropped on the scene?
If a revolver was used, it holds 6 rounds, 6 bullets in a cylinder. The cylinder is opened, shells are put in manually, closed cylinder, and then the weapon could be fired. In this case, according to the Warren Commission, two shells were removed manually and dropped at the scene. The shooter, or whoever had possession of the pistol, opened it up and took 2 more shells out, 2 more empty shells, and dropped them as he was leaving the scene.
In your experience as a police officer, have you ever seen anybody drop shells at a scene and reload?
No.
After they've shot a police officer in the head?
No. No. Normally, if a revolver was used, common sense would indicate that the cylinder would be opened and they would be dumped out, all of them at the same time, and then new ones would be put in.
Now, up here it mentions that there was one officer, Poe, who said he marked both casings with his initials, correct?
Yes.
And the FBI lab, they looked at them. Did they find any such initials?
No.
Did Dallas?
Dallas PD? No.
Right. When he testified, were the shell casings shown to him in front of the Warren Commission?
No. They didn't show it to him.
Right. And when Officer Poe appeared, he couldn't find his initials on the shell casings.
No.
All right. Next in order, this is an affidavit, a police report by Officer Odom. And again, it reaffirmed what we went through, correct?
Yes.
Then there's another shell casing from the crime scene found by Barbara Davis.
Yes.
Correct? And Barbara Davis was shown the casings. Was she able to identify where they came from?
No.
And then let me ask you about her affidavit. Her affidavit affirms that?
Yes.
Then she stated she gave the casing to an officer. She didn't know who the officer was.
No.
And then finally her sister came up with the casing a couple hours after the shooting. And they had to come back out and interview her as well, correct?
Yes.
And then was she able to identify the casings?
No.
And then finally, I think that takes us through that line. I want to see if I can get us to the wallet evidence. And there it is. So briefly, we're looking again at the video capture, correct?
Yes, that's a video capture I made of the newsreel from WFAA TV in Dallas on the day of the assassination, showing the wallet at the Tippit crime scene.
And this is a picture of the wallet at the National Archives.
Yes.
And then this is Officer Bentley, and can you summarize what he stated about his observation regarding the wallet?
After the arrest of Lee Oswald at the movie theater, the Texas Theater, they were transporting him down to the police station in the company of 5 other police officers. They asked him, according to this testimony of the officers in the car, they asked him who he was, asked him his name. He refused to comply. One of the officers removed a wallet from his back left pocket.
And that was inside Jerry Hill's car?
Yes.
And then this offers the best picture we have of the first wallet and the second wallet with a little highlighting. Do you have any opinion about whether it's one wallet or 2 wallets?
I don't have an opinion of that. I can't see the picture on the left is not clear enough.
Is it common practice to, when a wallet is found at a crime scene where an officer is shot to not report the wallet from the crime scene?
No. That would be an indication of, that would be something you'd want to notate.
That would be pretty critical in terms of any chain of custody, among other things, correct?
Yes. Especially if it has a potential suspect's name in it.
And alleged alias, correct?
Yes.
Okay, and then finally, if I can do this, I wanted to ask about the latent prints.
Hit escape.
Escape? Okay. Got it. All right, now, here we go. This is Lieutenant Day here.
Yes, this is a picture of Lieutenant Carl Day with the Identification Bureau dusting, presumably dusting the rifle for fingerprints or any latent prints that might be on it.
And this is a better display of the rifle about 6 o'clock that day, correct?
Yes, this is, Lieutenant Day brought this rifle out to the press who was assembled in the police station, showed him the rifle.
And what's highlighted in this particular sequence?
The highlight is his testimony was he was attempting to remove or lift a latent print off of the trigger guard on the right-hand side, and that's why you see this coloration of some kind in a black and white photograph. Normally the procedure would be you dust it, you put a piece of lifting tape and then remove it. What that does is that the lifting tape will completely remove, or majority of the print will be lifted, and there will be a clear space underneath.
And in fact, Sebastian Latona over at the FBI took a look at this same set of alleged latents the next day, correct?
Yes.
And what was his finding?
He found no identifiable prints and no evidence that a lift had even been attempted on the rifle.
And then Henry Hurt interviewed Vincent Drain and Day about this latent print, and Day claimed that he had observed it and showed it to Drain, but what was Drain's response?
He said Special Agent Vincent Drain of the FBI reported that, or told Mr. Hurt that he didn't believe there was even a lift to be, that a lift had even been done, or there was a latent print to be, that was on the rifle.
Didn't he say it was some sort of cushion?
Those were his words, yes, it was a cushion for the Dallas police to have something to fall back on.
Nothing further at this time?
Cross-examination. Ms. Webb, yes, you may. Can this be done in 15 to 20
Yes, Your
minutes or
Honor.
less? Thank you.
I'm going to be as efficient as I can.
Thank you.
Okay. I got a short amount of time, so I'm going to go quick, so bear with me. Okay. You would agree with me that both the Warren Commission and the House Select Committee on Assassinations, both of them heard all kinds of evidence, not just snippets of what we heard today, right?
Yes.
Okay. And both of them found that Lee Harvey Oswald was the shooter.
That was their final conclusion, yes.
Okay. So, and that was done after hearing everyone's testimony, everyone's sides for months, right?
Yes.
Okay. Now, the FBI, going to the rifle, the FBI actually told the commission that that rifle was actually reliable.
Yes,
Do
I
you agree with
remember
that?
reading, yes, I did read that.
Okay, and when you had the slides up there about the aiming, right? They had the 2 black spots, and
Yes.
you know what I'm talking about? Does everybody know what I'm talking about? Okay, on that slide we see how it went up and to the right.
Yes.
Well, we know he missed once, right?
That's the final conclusion, yes.
Okay.
One of the
so-
shots missed.
Right, and you know, who knows? He may have been aiming for the heart and it hit the head.
That's
We-
speculation, yeah.
Right, and we don't know.
Yeah.
Okay.
I would aim for the head, but that's just me. Body shots aren't going to do anything.
Is there something about your past you're not telling us?
If this was a court, Your Honor, I think I'd take the 5th.
Okay, I think that, you know, we will concede that the crime scene was not handled pristinely. I think we concede that, okay? But you would also understand police officers are, and you were a police officer, we're human beings, right? We make mistakes.
Sure.
Okay, and given that the President of the United States was just shot, isn't it conceivable that people didn't know what they were doing?
No.
It's
That
not
should have
conceivable.
been the complete opposite in my mind.
And that's for somebody that is properly trained,
They should have all been properly trained.
and they should have been, right? And
Yeah.
and we're talking about, and you were an officer in Kansas, 10 years after this was your first, after the assassination?
78 to 2001.
Okay, so, you know, and this is Texas police officers trained in Texas law, right?
Right.
Okay, now, granted, the science has been updated and changed, and procedurally, because of science has changed, things have changed as far as law enforcement's teachings, I guess I could say.
They're modernized, yeah. But the basic rules of evidence are continuing. They've been that way since the days of the 1800s.
But you agree with me now that based on everything that's happened over the years, now officers are trained much better than they were
sure.
back in the day?
Absolutely.
Absolutely.
Yeah.
Okay.
That's why, in this case, they had a specialized unit that would simply process crime scenes. That's all they would do.
Okay, it looks like we've dropped our audio, the feed. And hanging on to see if it's refreshing. I'm getting a circle refreshing. I got a feeling I'm going to have to just put this on pause and try to refresh.
I'm not a hunter, so I don't know anything about shooting what animals you would need to shoot with a specific gun.
Okay,
High-quality rifle, hunting rifle.
There'll be some witnesses in this case, right? And so you, as a police officer, you know how to do an investigation.
Yes.
Right? Okay. And you also know that I think Mr. Sindich was
I still have a problem here. Hang on.
some pieces from different news agencies. And as an investigator, okay, there was a radio. There's talk of curtain rod, confessions that's okay.
I would aim for the head, but that's just me.
Okay, I am going to have to restart the server. Sorry about that. I don't.
I think that, we will concede that the crime scene was not handled pristinely. I think we concede that, okay? But you would also understand police officers are, and you were a police officer, we're human beings, right? We make mistakes.
Sure.
Okay, and given that the President of the United States was just shot, isn't it conceivable that people didn't know what they were doing?
No.
It's
That
not
should have been
Okay, we're
the
back.
complete opposite in my mind.
And that's for somebody that is properly trained,
They should have all been properly trained.
and they should have been, right? And
Yeah.
and we're talking about, and you were an officer in Kansas, 10 years after this was your first, after the assassination?
78 to 2001.
Okay, so, and this is Texas police officers trained in Texas law, right?
Right.
Okay, now, granted, the science has been updated and changed, and procedurally, because of science has changed, things have changed as far as law enforcement's teachings, I guess I could say.
They're modernized, yeah, but the basic rules of evidence are continuing. They've been that way since the days of the 1800s.
But you agree with me now that based on everything that's happened over the years, now officers are trained much better than they were
sure.
back in the day?
Absolutely.
Absolutely.
Yeah.
Okay.
That's why, in this case, they had a specialized unit that would simply process crime scenes. That's all they would do.
Okay. Now, and there have been no confessions that somebody maliciously messed with fingerprints or boxes or anything,
No.
right? Okay, and there's been no prosecutions of that either.
Not that I've ever heard, no.
Okay, so let's go. Sorry. Okay, so we talk about, what happened that day. And as a former officer and having training and experience, let's talk about some of the facts that we do know, okay? We do know that, Oswald was separated from his wife, right? She was staying with Ruth Payne, right?
Yes.
Okay, and Marina testified, or not testified, she told the officers that she's the one that took the photograph, right? At that time, that's what she said.
That's what I read, yes.
Okay, and she actually, at that time, led the police officers to the garage to find the rifle, and it wasn't there, right?
No.
Okay,
It was Ruth Payne did that.
I'm sorry. Okay.
It's okay?
And he left, Lee Harvey Oswald left his money and everything behind for Marina and his wedding ring.
I've only
it was
read the
found
money.
there.
I've only read the money was left behind.
Okay. Now, and we also know that the day before the assassination, there was talk of curtain rods, right?
Yes.
With Mr. Frazier.
Yes.
And we know that he went on an unusual day to pick up a package, right?
According to Buell Frazier's, it was different. It was not typical of Oswald on that day to be asking for a ride, yes.
Okay, and then we also know that the next morning there was a package with Lee Harvey Oswald that said, hey, these are curtain rods I picked up the night before, right?
Are you asking if Oswald told Frazier
Yes.
that these were curtain rods that he
Yes.
placed in his car? That's what the information was, yes.
Okay. Now, when he was being interrogated, he claimed that there was no package. So that's a lie, right? Okay. And he was not seen exiting the Texas School Depository with any package. And interestingly enough, he actually left the scene. How many people did you see staying to see what was going on, and he takes off? Do you find that consistent with somebody that is committed a crime?
You're asking me to speculate on somebody who's...
I am.
I'm not sure I could give you a good answer on that.
Okay.
If I was doing it, if I had just committed this heinous crime, yeah, I'd be leaving.
Right, okay. And, we went through this in our opening, and I'm trying to go quickly. Now, there was talk about the rifle that was purchased in March, okay, and I think Mr. Simpich showed that. And there was an attempt on General Walker's life in April. There was an attempt on his life.
Yes.
Okay. Now, in Oswald's possessions, okay, let's go back to the search warrant. In his possessions, okay, there was a radio, a map, binoculars, and a gun holster. If you don't have a gun, why do you have a gun holster? And letters to Oswald from the, and the P.O. box. We beat that to death. But, okay, going forward, based on the evidence that we found and the facts, he had handwritten notes about General Walker, and that something was going to happen that would lead to Lee Harvey Oswald's capture. You'd agree with that was found?
I'm gonna say yes, because I don't know enough about the General Walker shooting or the circumstances around it.
Okay, fair enough, fair enough. And are you aware that Marina said that Lee told me he tried to kill General Walker?
I've read that, yes.
Okay.
I've spoken to Marina Oswald multiple times.
Right, and you've
about
actually
that.
talked to like 30 some odd witnesses
I
in
have.
this case, right? And so you've, as a police officer, you know how to do an investigation.
Yes.
Right? Okay. And you also know that I think Mr. Simpich was quoting some pieces from different news agencies. And as an investigator, you don't want to get your information from a news agency, do you?
No.
All right.
I never get it right.
Okay. Okay. And also, if we go back to tracking Oswald as he left the Texas School Book Depository, he actually had with him that bus ticket, right, for the transfer.
Let's put it this way. That bus transfer ticket was found in his pocket after he was arrested.
Okay. After he was arrested, he had the bus ticket in his pocket. Okay, that puts him leaving, and we heard the clip from the bus driver, and then from the taxi driver, and then from the rooming house, right? Okay, so we have tracked him, and all the while, right, the president is at Parkland Hospital, there's commotion going everywhere, and what is he doing? He winds up at the Texas Theater, right?
That's where he was arrested, yes.
Okay. And when he was arrested, he had the murder weapon of the let me rephrase. He had a revolver with him that he brandished to officers.
That's what the Warren Commission said he had done, yes.
Okay. And I'm not sure, are you familiar with Texas law and the law of parties?
No.
No, okay. So would it surprise you to learn that, say, in a bank robbery case, if somebody's the getaway driver, they're just as guilty as the bank
yes,
robber?
okay. An accomplice, basically.
Right, okay.
Yes.
In Texas, we call it the law of parties. So would you say, let's throw out all the evidence, which I don't suggest we do, but let's hypothetically, if we throw out all the fingerprints and everything, We still have Marina and what she said. We still have the eyewitness accounts of where he went and his actions after, right? You'd agree with that?
We have that, yes.
Okay, so we have all of that evidence.
If I could just throw in something, eyewitnesses are the worst person to have to a crime.
And so are ear witnesses, right?
That's right.
Okay, all right. So given all of those facts, and if we take where he went, what he did after, and how he was caught, and how the guy at the shoe store said he looked nervous, right?
Yes.
Going into the Texas Theater.
Yes.
Okay, we take all of that. That would lead us to the conclusion that he did something wrong.
Not necessarily.
Okay, that would lead a reasonable person, could lead a reasonable person to conclude that he did something
Well,
wrong.
let me, if I could ask you a question. If this, no,
You need a law degree and a license.
I'm sorry. Okay. I was working on that and it didn't work out. Didn't work out.
Okay, so,
But to answer your question, yeah, if you'd rephrase it, I will answer it.
okay. And then there was some mention about marital privilege, okay? And just so the jurors know, in Texas, marital privilege is invoked by the party that's testifying, not
Okay.
by the defendant.
Right.
So that would be her choice. And we all know that she testified in she got on the news and talked to people, right?
She also testified at the Warren Commission.
All right, okay. So I think, okay, and then, all right.
Yeah, well, I'll wait till she's finished.
So that takes us back to what we have to prove as the state, right? Everybody agrees on November 22nd, 1963, in Dallas County, Texas, Lee Harvey Oswald intentionally or knowingly caused the death of John F. Kennedy by shooting him with a rifle, right?
I would agree with 1, 2, and
Everything but Lee Harvey Oswald?
intentionally knowingly or caused the death of John Kennedy.
Okay, so you're saying that the 3 shots from the Texas School Book Depository are not what killed him?
No, I'm not saying that at all.
Okay, so intentionally or knowingly is intentionally somebody shoots a
Yes.
rifle in this case.
Yes.
That's an intentional action,
Sure.
right? Okay, so you'd agree somebody intentionally did it?
Absolutely.
All right, okay, and he died, and it's him. So the only thing really in contention is
Who did it?
who did it. And you agreed with me that 2 committees have agreed that Lee Harvey Oswald did it.
That was their findings, yes.
Pass the witness.
And that's it, there's no rebuttal, correct?
No, there's no rebuttal, just I was going to do what Mr. Pappas did earlier and just remind the court that,
2 minutes.
yes, that we...
Stand and
Oh,
deliver.
okay, all right, that the, we don't agree that the marital privilege would not apply, and that it would probably go to the weight of the evidence, but just like Mr. Pappas had said earlier, there's a separate marital privilege that was under section sub A. Thank you.
Okay. And I would like to take, again, some judicial privilege and ask the witness 2 additional questions, and I'll give both sides a chance to follow up on that. We're talking about the rifle itself. And we know a lot about this rifle from your testimony and some previous testimony. Many people in this room are familiar with the M1 carbine.
Yes.
And you're familiar with that weapon as
Yes, sir.
well. Compare the 2 weapons just briefly in terms of reliability, accuracy, and ability to fire a bullet with some degree of reliability, if you would.
I have to admit, I've never fired an M1 carbine, but I've fired a lot of other long-barreled weapons. If an M1 is much more reliable, much more accurate. It was used by the American military in World War II. Same process. However, it's a semi-automatic rifle versus a bolt action. Bolt action in a military situation is suicidal to me. You want to have capability of rapid fire. The M1 would have done that. That's probably why the American military didn't go to a bolt action rifle for the infantry.
Let me give you another example, a Weatherby hunting rifle, which is a
Okay.
bolt-action
Yes.
rifle.
It's a Weatherby is a high-quality hunting rifle, usually a .308 or .306 caliber, bolt action, preferred by most hunters to be the standard deer rifle, what have you. I'm not a hunter, so I don't know anything about shooting what animals you would need to shoot with a specific gun, but a Weatherby is a high-quality rifle, hunting rifle.
Is a rifle a firearm?
Yes.
Okay. And a firearm, would you say that this rifle, the subject rifle in this trial, is a device designed, made, or adapted to expel a projectile through a barrel by using an exploding or burning substance?
Yes.
Okay. Is it a deadly weapon? Is it capable of causing death or serious bodily injury?
Yes.
That would be typically the follow-up or part of the case, the state's case in chief in proving, and they have to do this in trials. It seems silly that they have to do that, but in every prosecution, that's what the state's required to do.
Yes.
That's why I thought I'd add that for the jury and the folks that are here listening.
Yes.
Does anybody want to follow up with any of those questions? It's just mostly informational questions.
I think both sides are resting.
Very well. You may stand down, sir. Thank you
you,
very
Your Honor.
much. We're going to charge the jury in 10 minutes and excuse them, and then we're going to set up our panel for the ethics part of this. And so we ask everybody who is here for the CLE course, if you're interested in getting ethics credit, you have to stick around for the remainder of the program. And that's, as we all know as lawyers, the hardest kind of CLE credit to get it. So please take a brief break, come back in about 10 minutes. We'll charge the jury, and then we'll start our ethics discussion. Thank you.
And if you're not interested in ethics credits, you have to sign out. If you just wanted the non-ethics credits, you have to sign out on the way out. If you're staying for ethics, you don't have to do it right now.
Thank you for adding that.
Well, there you have it. Trial's winding down, I think, and we're on a break right now. So, let me add that. I think from some of the emails I'm getting, people thought it would be easier. They didn't think a prosecution would be fighting back, but the prosecution is, and they're making it tough, and they're not taking anything for granted. And although this sounds like you're defending the world is flat, that's what they're doing. They're defending the case, trying to make it seem somehow plausible that the other House Select and Warren Commission got it right. And I think the basis of that is just that, look, the other guys got it right, how can it be wrong now? And I guess this will be the discussion in the next weeks after this. But, people who want to cling to that, I think that, the new research is going forward, people are clinging to something from 1964. I think that's really a good way to describe the evidence, clinging to it. So, I'm not going to make too much commentary right now about that. We'll do that another time. But, people are, well, Frank, you're writing, is there supposed to be a verdict? I'm not sure, but I understand that they are going to be watching the jury to learn, so as they are in their deliberations there's a camera. I don't think anybody's bugging them, but they're just going to be viewed, and that will be, useful for people. This is a law school, so they're trying to figure, how do they make the best law, and how do you win, how do you lose, things that can go wrong and go right. And I'll leave it at that. I do appreciate anybody writing in to say where they're from, what country, whatever, or where they are at. So do that again, please, anybody who hasn't written to me yet. And let's just put some music back on. And I'll let you know when the trial's back from recess.
Peter up here, and Brooks and so forth. Let's get seated, please. Is this everybody who is remaining for the rest of the trial? I mean, there were a lot more people in here earlier. Have the others left? Do we know? Someone just poked their head out in the hallway and asked people to come back in, if they would. This is very important.
Okay, looks like they're getting ready to start up again. The judge has entered.
All right. Thank you. We have all of our jurors here. Missing one. I got to have my jurors here. Or do we know where that other juror is? Would you please just put one more check, and then if they're not back, we'll manage without them. But I want to try to make sure that we have as many jurors here as possible. This is the last 3 miles of the marathon, folks, the most important part of the race. Why don't we get that out of the way?
While we're waiting for the last juror to come in, there was a comment made earlier today about CAPA, and I just wanted people to know that CAPA is a nonprofit organization. We're one of the co-sponsors here. We're not a conspiracy theorist organization per se. We put on this program. We have a mock trial. We tried to have a full hearing of the facts and the evidence in this case. So I just wanted people to know that, I know there are a lot of people out there that are on the fringe, but we consider ourselves, our objective is to get to the truth and to, and do it through means like this. So I just wanted people to know that, some members of CAPA felt we were insulted by the comment, and we just wanted to set the record straight. Okay, thank you.
And to further maybe explain that during the competition, their competitive juices are flowing and people are arguing their case, and so I would ask you to make that the grain of salt that you add to the understanding of that, ladies and gentlemen. Thank you very much, Larry, for that final comment. Now let's get on with the legal part of this. Typically, well, not typically, at the beginning of every criminal trial, the indictment or the charging instrument is read to the jury and a plea is taken by the defendant. We didn't do that because we just jumped right in on this because we didn't have a defendant here. But I'm going to ask the prosecutor at this time to read the indictment so that the members of the jury can hear what the charging instrument says, because your decision will be based upon what's in that charging instrument. The jury instructions I will give you that will inform your deliberations and the decision that you make. And I'll give you a couple of additional instructions that are not in here, but based on current law that I give to all jurors. So, Ms. Webb, would you please read the indictment?
Yes, Your Honor. In the name and by the authority of the state of Texas, the grand jury for the county of Dallas, state of Texas, duly organized at the October term AD 1963 by the Criminal District Court of Dallas County, in said court and term, upon their oaths present in and to said court, that one Lee Harvey Oswald, hereinafter called defendant, in the county of Dallas and state aforesaid, on or about the 22nd day of November 1963, and before the presentment of this indictment, did then and there, with malice aforethought, commit murder of John F. Kennedy, to wit, by shooting John F. Kennedy with a rifle. And just for clarification, Your Honor, that is the indictment as the law was written back in 1963.
And does it end with against the peace and dignity of the state?
And against the peace and dignity of the state.
It's required in every indictment to say that, okay? And for obvious reasons, the court will enter a not guilty plea for the defendant. So these are the jury instructions that I will read, and they may, I would say, in substantial part will agree with the indictment, but there may be a few changes here and there that shouldn't concern you too much. Members of the jury, the defendant Lee Harvey Oswald stands charged by indictment with the offense of murder alleged to have been committed on or about the 22nd day of November 1963 in Dallas County, Texas. The defendant has pleaded not guilty. Our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual. Person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Now, if you find from the evidence beyond a reasonable doubt that on or about the 22nd day of November 1963 in Harris County, Texas, the defendant Lee Harvey Oswald did then and there unlawfully, intentionally, or knowingly cause the death of John Fitzgerald Kennedy by shooting John Fitzgerald Kennedy with a deadly weapon, namely a firearm, then you will find the defendant guilty of murder as charged, unless you so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict not guilty. There is no definition of beyond a reasonable doubt in the state of Texas. There was for a period of about 2 to 3 years, and that definition was then taken back by the Court of Criminal Appeals. But I will instruct you as follows, and we will compare with other kinds of cases. In a civil case where people are contesting over money or property, the burden of proof by the plaintiff is preponderance of the evidence. That means by a greater weight of the credible evidence. So if somebody has established liability in a civil case by 50.5%, they win the lawsuit. In a family case where the state of Texas tries to remove a child from a home because of allegations of abuse or neglect, then the burden of proof is clear and convincing evidence. It's a much higher burden of proof because there's more at stake in a case like that, right? In a criminal case, it's beyond a reasonable doubt. The state is never required to prove a case beyond all doubt. It's beyond a reasonable doubt. It would be impossible for anybody to prove anything to anybody else who is not a witness to a case beyond all doubt. To prove something to you beyond all doubt, you would have to been there and see it clearly and remember it clearly for it to be proven beyond all doubt. That's not possible because under Texas law, you cannot serve as a juror and as a witness at the same time. There is a specific prohibition in the Code of Criminal Procedure against that. Another way of describing proof beyond a reasonable doubt is that it does not require, the state's proof does not require perfect proof because evidence typically comes from human beings who are not perfect. And that's how I explain it to jurors in many of our trials. So there is some room for margin of error, but not much. And that not much is decided by the 12 of you, how much you want, but it cannot be by perfect proof and beyond all doubt. Is everybody clear about that? It has. There's a much at stake in a criminal case. Somebody's life is at stake, perhaps in a death penalty case, or their liberty for the rest of their life, or their money in terms of fines and probation requirements, et cetera, et cetera. So That's what beyond a reasonable doubt. And I typically let the lawyers argue what they believe beyond a reasonable doubt means, but I'm telling you that's what I think it means. Now, in terms of testimony, I assume that Mr. Oswald did not testify in this case, and I would charge the jury as follows. Our law provides that a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant elected not to testify, and you're instructed that you cannot and must not refer to or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. A grand jury indictment is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence of guilt, nor can it be considered by you in passing upon the question of guilt of the defendant. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that he has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. Prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof exclude all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to their testimony, but the law you shall receive in these written instructions, and you must be governed thereby. After you retire to the jury room, you should select one of your members as your foreman or forelady or presiding juror, however you want to refer to this person. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify your verdict by using the appropriate form attached hereto and signing the same as foreman. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. No one has any authority to communicate with you except the officer who has you in charge. After you have retired, you may communicate with this court in writing through this officer. Any communication relative to the cause must be written, prepared, and signed by the foreman and shall be submitted to the court through this officer. Do not attempt to talk to the officer who has you in charge, or the attorneys, or the court, or anyone else concerning any questions you may have. Your sole duty at this time is to determine the guilt or innocence of the defendant under the indictment in this case, and restrict your deliberations solely to the issue of guilt or innocence of the defendant. Your verdict must be a unanimous vote of all members of the jury. Following the arguments of counsel, you will retire to consider your verdict. There will be no arguments of counsel today because you have already heard them. Now, I usually give other instructions to the jury as follows. Nothing that the court, that is the judge, that has been said in this case should not be considered as the court taking sides of either side in this case. What the lawyers have said in this case, I tell typically to a jury, that's not evidence. Only the response of witnesses to their questions, that's evidence, or exhibits admitted, etc. But of course, since this is an instructive mock trial, you may consider the lawyer's arguments, but I want you to take their arguments with a grain of salt and try to look to the evidence that you saw, that is the testimony of witnesses who were permitted to testify under the oath, and try to go with that as much as possible, and the lawyer's arguments guide you the rest of the way, okay? I think that's about it. Does either side wish for me to give any additional instructions to this jury?
Just no research on that.
Very well. Then at this time, I'm going to excuse the jury to deliberate your verdict. Do we have someone from the school to shepherd them up to the dean's office or wherever they're going to go? I think they have a room that they're going to go deliberate while we're discussing ethics issues in this courtroom in their absence. If somebody could help me with that, I'd be grateful. Can I give these instructions to one of the members?
Oh, okay. Yes.
There's a verdict form on the last page. Just fill it out accordingly. Yes, any exhibits, counsel? If you want to give the jurors any exhibits, please give it to them now.
Jurors, we're good.
While the jury is going out, I just want to let you know we have two ethics panels. The first is going to be a presentation by John Orr, who is a former director of criminal enforcement of the Justice Department Antitrust Division. In 1995, he prepared a report on his own investigation of the assassination. He presented it to Janet Reno, who was then the Attorney General. She then forwarded it to the FBI. And okay. We're going to be using his report and the response of the FBI to it to talk about the obligations, the ethical obligations of a prosecutor when they get either new evidence or the science changes. Then we're going to have a brief presentation by Judge Carahan on the
The Michael Morton Discovery Act.
The Michael Morton Discovery Act, which is it's a statute that requires prosecutors in Texas to affirmatively turn over evidence,
all of the evidence,
exculpatory evidence. And then we're going to conclude, we're going to compare and contrast how Lee Oswald's rights were, while he was in custody, how his rights were handled in 1963 and compared to current practices now.
Bring them back in.
So that's interesting stuff. It's ethics. So the lawyers in the room, you're going to get 3 hours of ethics credits total. You have 1 hour from yesterday and 2 today. Anyone else who's not a lawyer and not getting ethics credits, you can certainly stay and listen. It's very interesting. So with that, I'm going to go up to John. Is there a second chair there? Yes. Okay.
We've got to get whether there's going to be a break.
Do we need time to set it up?
We got to set up.
Oh, okay.
We need the tech guy.
I need a tech guy. Okay. Randy? Oh, Chris. Okay. All right. We need a tech guy to help us set up.
Just plug in here. Is that all we need to do?
Yep.
Move that one around this side.
Yeah, and you might have just like to get a little closer, but do you have audio in your presentation?
No.
Excellent. You're good to go.
And while we're waiting to set up, John Orr, this presentation, Peter Russo was the producer. This was on Fox News, had a 2013 50th anniversary special on the Kennedy assassination. And this program was produced by Peter Russo, and John Orr was one of the presenters. And they also developed a very interesting animation that we didn't put this in the trial because for various reasons. But John believes he has found evidence both from a trajectory perspective and other perspective of a second shooter on the top of the county court's record building. So there'll be an animation as well. But that's obviously wasn't part of the mock trial for a variety of reasons, which we won't get into. Okay.
Okay, thank you. This is the title of the report that Larry was mentioning that I submitted to Janet Reno in 1995 in April. This was a personal project while I was a senior official with the Justice Department, a private project that nobody knew about until I turned it in. And it is, and was at the time, as far as I know, the only complete visual reconstruction of all the shots in Dealey Plaza on that day. I've done
years and years of research, I've never seen any other report, study, or program that visually retraced all of the bullet paths and provided all of the evidence to support it. And the evidence I'm relying on is the raw evidence and the official record of the two investigations. This analysis, you'll see, is consistent with every bit of the physical raw evidence that was assembled in the two investigations, and it is consistent with all of the expert testimony to a reasonable degree of certainty in both of those investigations. So this is not something out in left field. This is original evidence. And Larry mentioned the animations by Peter Russo, who's sitting over here, and I'm greatly indebted to him and his team for, we worked very closely together for months on the 50th anniversary, and they created all the animations you're going to see in this presentation. I need to get a mouse. There it is. Okay. The first animation is of Dealey Plaza. You've seen this before during the last 2 days, but all the shooting was done basically in the center lane into the limousine. All of the shooting into the limousine was in the center lane from about here down to about here. This is where Zapruder was standing, and we'll pan on down and see again what you've seen many times, but I'll show you again the Oswald window on the 6th floor southeast corner of the Texas School Book Depository, and the other buildings immediately around it. The FBI, Secret Service, and CIA all correctly concluded shortly after the assassination that 3 bullets landed in the limousine. This is all 3 agencies concluded that the first bullet hit the president in the back, the second bullet hit the governor in the back, and the third bullet hit the president in the head. However, when a few weeks later the evidence was fully developed about the James Tague bullet down at the very far end, the bottom of Dealey Plaza by the triple overpass, the Warren Commission realized they had a dilemma. By then, the evidence was clear that Lee Harvey Oswald had fired 3 shots and 3 shots only. The commission, make no mistake, was a politically appointed committee with a political agenda. Their objective was to prevent World War III by proving that Oswald was a lone nut and had done it by himself with no help. They took this mandate very seriously and never really considered the possibility of multiple shooters. I could not find 5 minutes of deliberation in all the archives records I read of the Warren Commission looking at multiple shooters.
Now, you actually went to the archive?
I've read everything that's publicly available, tens of thousands of pages of all the original evidence and all the internal notes of the commission.
You've had more access than other people.
I had access to the original records, the magic bullet, the president's coat, the president's shirt, the curved mark you're going to see where the bullet hit by James Tague. I've looked at all the key evidence right up next to my nose, and I know what it looks like. I know what's there. So after learning about the Tague shot, the commission explored whether all the injuries they originally thought came from 2 separate bullets were really only caused by 1 bullet. And this is where the single bullet or magic bullet theory was born. All right, a draft being circulated, the Warren Commission said in one sentence, a bullet had entered his back at a point slightly above the shoulder to the right of the spine. When that draft was circulated, Gerald Ford wrote some handwritten notations suggesting this change. A bullet had entered the back of his neck slightly to the right of the spine. The final commission report, which all of you can read, says at that same sentence, a bullet had entered the base of the back of his neck, slightly to the right of the spine. So very similar to what Gerald Ford had suggested, and saying that the bullet hit in the neck. There's just one problem with that. The bullet hit in the back, not the neck, and we're going to show you that with crystal clarity, I hope. All right, this is where the Warren Commission placed, after moving it up from the back, they placed the first shot into the president, entry in the right base of the neck, right of the spine, just at the base of the neck. The head injury is shown above, but we'll get to that later. This is the Warren Commission bullet path. entering in the neck, exiting at a point lower in the front of the neck, in the center. And the Warren Commission speculated that the bullet, in passing through the body, had hit only soft tissue. And as you learned from Mr. Haig, the MC bullet and only a few inches of human tissue will go in essentially a straight line and be virtually undeformed. The problem was this was just a guess. The autopsy had failed to dissect the bullet track. So the Warren Commission had no way of knowing whether that bullet had hit only soft tissue, and it in fact did not, and I will show you that from the official record. All right, here's the magic bullet path you've heard about a lot for the last 2 days. This is one of the Fox animations, and we recreated the Dealey Plaza to scale, all the buildings to scale, the streets and everything. And this is projected down from the 6th floor window, Oswald's, into the limousine. And this is what the magic bullet would have you believe if you accept this theory. Oswald's window, the yellow line is the bullet path. Goes in, according to their entrance, in the neck, not the back, in the neck, coming downward, outside the neck in the front center, coming into Governor Connolly's right armpit at a severe right to left angle, not straight on, but right to left and severely downward, about 27 degrees, according to the testimony you heard. Coming out the center of his chest, going to the right, let me back that up, going to the right, into the top of the wrist, exiting the underside of the wrist and coming back directly to the left to the inner left thigh. There you can see it. So we don't know the exact position of the right arm because it's below the car, but we know from his movement shortly thereafter he lifted it up to protect his intestines as he turned around. So we're almost positive it was on his right side, and it's not in the path of the exit of the bullet coming out of the chest because you would have seen his Stetson. So we know it's not in the direct line bullet path. It had to have detoured to get over to the right to go through that risk and then come back to the left to enter the thigh. So,
Again, these are all based on the records in...
official records. All right, I told you I would show you the bullet was in the back. Here it is. Here's the president's coat that I examined and measured. This is not my photograph, but I measured it the same way they did. 5 3/8 inches down from the top of the collar to slightly to the right of the midseam, small oval hole. Here's the shirt, same spot, 5 3/4 inches down from the top of the collar, slight to the right of the midseam, and a small oval.
And this was a fitted shirt that he would be sitting on.
Right.
So
Tucked in.
Right.
All right, so this shot, the Croft slide, was taken about 2.5 seconds for the first shot. This is the slide, and then the lower is an enlargement. And you see his coat and presumably his shirt was slightly rippled, maybe an inch bowed up at that point. So that means that the measured distance on the shirt and coat are slightly lower than where it would have entered the back.
But it's not the 6 inches of
Not pulling up over his head like that to get the coat up where the neck Warren Commission entry is. Okay, so further evidence. The original autopsy drawing, you remember the Warren Commission draft language slightly above the shoulder to the right of the spine, so that's right there, and that's where the Dr. Humes drew it. Bullet entry in the back, not the neck. And here is the photo, which helps you. The HCA made a photorealistic drawing of the same photo. So it's like you're looking at the photo and you see the oval hole, small oval hole in the back and not in the neck. This is where the Warren Commission would have you believe up here that it entered. So I hope you're convinced by now that this bullet entered
Okay, we lost our audio again. I'm sorry about that. I gotta reset something here. I don't know why we lose the stream. It seems like every hour on the hour. Something's going on here. And I'm just looking for the link to reopen that. Okay, here we got something now.
The HSCA the photography panel of experts concluded that by frame 207, again 3 frames later, he's reacting to an extreme external stimulus. That was the bullet. Here's a close-up. You see him at 204 immediately before the shot, hand raised in a wave immediately after the shot. Too fast to be a voluntary movement. It comes down, the head goes left. There's the governor looking right and Jackie looking right. They're waving at the crowd, all of them. Or governor's not waving, he's looking at the crowd. And here's what happened with the first shot from the 6th floor. And this was a Lee Harvey Oswald shot from the 6th floor. And Peter and his team and I insisted that they do overlays. I'd never seen an animation on TV or anywhere else where they actually overlaid to the Zapruder frames, because the animations you see are usually grossly distorted. So I didn't want that to happen, so I had them overlay to the actual frame and then run the animation from those overlays. You can see what happened. Came down from the 6th floor, entered the back where we now know it entered, exited at a higher point, still going right to left, hit the chrome strip above the mirror, rear view mirror in the center of the car. This barely missed the governor's left ear. He senses that, the whizzing and the sound of it going by, and if you watch immediately after this, he ducks his head to the right and he winces. That is in direct reaction to this shot. You'll see it around frame 230. All right, here's the bullet dent and a close-up of the same picture to the right. You can see from the shape of the dent in the chrome that it's a low to high and right to left. The way that oval is shaped, just like a bullet hole, you can tell pretty much the direction that bullet came from. And the FBI agent, the ballistics expert, testified that this bullet was moving at a fairly high but not full velocity. He said if it was full, it would have penetrated, gone right through the chrome, but it was substantially reduced but still fairly high velocity, which is a perfect description of a bullet that has gone through the top part of the president's body and smashed into 2 bones. Second shot, 1.75 seconds after the first shot. The House Select Committee determined that 1.5 seconds was the bare minimum for Oswald to fire 2 shots, so he took just over the bare minimum to do this one. This one hit Connolly in the back, as all the agencies determined in the beginning of the investigation before the Warren Commission cranked up. Hit in his chest and went down. Here's a close-up. The governor, after turning and wincing from that bullet barely passing his left ear, is turning around to see because he believes the president's been shot. And as he turns around, he is hit in the back in this, immediately after this frame. He said that it felt like a blow of a fist. And this is 2:38, 2 frames later, a ninth of a second later. I believe Dr. Thompson measured this in his book, Six Flags in Dallas, and that was one of the things I used in my report, his chart showing this right shoulder dipping down in 1/9 of a second, far too fast to be a natural movement. His cheeks are puffed out because his right lung has collapsed. His hair appears to be flying up. It looks like his eyes are closed. So this is his full reaction to that shot. All of the doctors at Parkland who worked on this chest injury said the shoulder was pointed toward the shooter, almost like he was directly pointing his shoulder at the shooter. That was how sharp that right to left angle was. And this is the only area where that is the case. And Connolly, his wife, and virtually all the experts who looked at it in the first couple of weeks agreed that he was shot around mid-2:30. It was only changed when the single bullet became vogue. Here's the trajectory from the 6th floor. Again, Oswald shot too fast to take aim at the president, so he missed him over his right arm, hit the governor by mistake. And you see the overlay again with the Zapruder frame, bringing the Stetson up to protect it as he turns to the right so it won't get smashed. And Stetson's nowhere, the rest is nowhere in line of the bullet path. It goes straight into the left thigh. This is what it looks like on the inside. Enters the armpit, comes out just below the nipple, center of the chest. That red circle indicates the 2-inch hole that was blown from the bullet, knocking out 4 inches of the 5th rib and starting to tumble as it comes out, creating the big hole. And it continued to tumble and went back and forward into the thigh. It buried the base end into the thigh, dropped one little flake of lead in the thigh where it still remained, and fell out in his pants, where it was recovered on or near the gurney where his pants were removed later at Parkland. This is that magic bullet we've been hearing so much about. It's not magic at all. It only went through the chest and landed in the thigh. The top half, I inspected this, as I said, in the archives, and it is perfect, essentially, from the top half up. The nose is perfectly round. Everything is great. Down at the lower half, you've got a little flattening right in this area. You can sort of see the shadowing there. It's flattened, and you can definitely see it on the base view, the flattened side. That's from as it entered the chest as a pristine bullet going smoothly. It started to yaw slightly, and the back end went over and slapped the rib and knocked the 4 inches of rib out, flattening the lower half of the bullet. And that's really the only damage to it. Absolutely impossible that this caused all the damage alleged by the single bullet or magic bullet theory. All right, we heard a lot about, particularly today, about the yawing bullet entered the governor's back. That's another prong that they rest the single bullet theory on, that it must have come out of the president first because it was yawing when it came into the governor. Not so. You have a small oval hole in the governor's armpit coat, just like the oval hole in the president's back coat. Small oval hole in the shirt to the right, picture there, entered there. The chest surgeon who treated this wound said that he had treated 1,000 bullet wounds in his career, and this hole in the back was a small, clean oval of a pristine bullet entering in a tangential or sideways angle from the 6th floor, and that it was not tumbling. And since we don't have any photos of the injury, we have to rely on this extremely experienced surgeon's word. But, as you probably heard today, Both investigations, Warren Commission and HSCA, used a surgical scar. After he cut out that small oval hole, he created a scar which coincidentally was the exact length of a bullet, sideways bullet, 30 millimeters, 3 centimeters. So both investigations used that 30 centimeter, 1 1/4 inch length to say this bullet was sideways when it entered the governor's back. Didn't happen. And Dr. Shaw told them that it didn't happen. Both investigations, they buried and ignored his testimony and still said that it was going in sideways. All right, now we're at the headshot, the third shot. Frame 312 of Zapruder. It's about 4.15, exactly 4.15 seconds after the second shot in the governor's chest. Here's a close-up. The president has tilted over to his left. He is bowing down slightly in the front, and he's looking slightly to the left of center. You see the governor there. He's leaned over against Nellie, and his arm is up holding his Stetson. You can see the cuff of his French cuff there, the white. So it's up in the air. Now, his radial nerve was partially severed, as you've heard, when the bullet hit his wrist. And all of the medical experts said it would be impossible or nearly impossible to continue to hold that Stetson with his thumb after that injury. He's still holding it with his thumb over 4 seconds after his chest has been hit.
And your trajectory shows that his wrist was not in the...
It was not in the path of the second shot. All right, here's the actual headshot. Enters, you've seen this too, this is the photorealistic drawing. Enters the very center of the back of his head, oval to the right, indicating a left to right. Everything about this shot is left to right, and that's going to be very important. Left to right oval, clean oval, pristine bullet. This is a near perfect shot at 100 yards. You've heard all about Oswald's rifle and his mediocre abilities. It would be like winning the lottery for him to have made this shot. This was an expert rifleman firing a very high-powered, high-accuracy gun who probably hit within a silver dollar of where he was aiming at 100 yards. This is the HSCA drawing. Now, this particular drawing, they have others, but this one does not show the gaping hole, missing skull all the way from the entrance to the exit wound. This whole part is blown out. They're just showing here representing the entrance and exit wounds of the bullet. Now, just common sense to me, and I hope you can see it too, this bullet is moving towards Zapruder. This is the frame 312 head position from Zapruder. Enters the center of the back of his head, exit his right temple. That bullet is moving closer to Zapruder. The right temple is closer to Zapruder than the center of the back of the head. At all times during the assassination of the motorcade, the limousine was left of Oswald. Oswald was to the right rear of the limousine. So there is no way left to right shot can come from Oswald's position.
So this is a different angle.
Different approach angle, left to right instead of right to left. Here is the official drawing of the brain, HSCA. I've added the two lines, the black line and the red line. The black line approximating the center line of the brain, and the red line is the path of the bullet. And you can see, obviously, a strong left to right orientation. And here's the third shot. Well, here's third shot path. All right, when I first started doing my research, I said to myself, the first shot didn't hit the wrist, the second shot didn't hit the wrist, so sort of by elimination, the wrist must have been hitting the third shot. So I took that HSCA drawing, superimposed it on the president's head at 312, and did the entry and exit points. And you see the governor's forearm is sticking up, his right arm very visible, and the cuff is visible, the hand and the Stetson all visible. And I ran that HSCA line with the entry and exit points in the president's head. And it will come down shortly, I hope. Okay. Going through the official entry and exit holes, lands directly at the point where the hole in the governor's coat, the cuff French cuff hole, and the wrist hole. All those are in a straight line at that point. That was the position the governor's wrist was in when it was hit, and the radial nerve was severed, not 5 or 6 seconds previously. So here's 312 close up on the governor. You see again his arm, French cuff, hand, etc. 1/18th of a second later, 313, that arm has been driven about 6 inches forward. As you can see, it's considerably flattened out, totally different perspective, and the Stetson has gone down below view. I found in the bowels of the archives again an internal memo from one of the Warren Commission staff attorneys who said that he noticed this change from 312 to 313, and he said, noted the forward movement. He said, this is too fast a movement to be voluntary. We have to look into this further. Of course, they never did. Never saw another word about it. All right, this is the animation. I'll show you the overlay again with the Warren Commission Zapruder film. All right, there's 312. There's the overlay. You can see it's accurate. And let me stop here. I asked the Fox animator, once I established this overlay was correct, I said, you find the line. I don't want to influence you. Run that line where it goes. It really only goes to one point in space. Once you get these, with this clear frame from Zapruder, and once you get these 3 points lined up, that only leads to one place in space, and this is where it leads. Back that up, sorry. I have to run that through again. Okay. See the overlay again. See if it's accurate in your own mind.
Which building is that?
County Courts.
County Records Building Annex. When I did my report in 1995, I used a bust of President Kennedy, a protractor, and a long piece of string, and a primitive computer technology 3D program, and I put the shooter exactly this spot. And when I came back to the Fox animator, she said, this is what I came up with. I had no idea where that line had led her. And if you're good at Googling at all, you can go online and see that a number of this person's associates will tell you or said that he was an expert marksman. He was on the roof of the CRB Annex during the assassination. He had a high-powered rifle, and he allegedly told at least one or more people that he fired one shot and one shot only. I'm not going to give his name because I'm not ready to accuse the person who I believe killed the president.
Now, was this a fully military jacket, or is this a soft?
I'm getting to that right now. You've heard a lot about this too. This was a soft-nosed hunting bullet, or hollow point, which is the same thing ballistically. The exact opposite of the hard-shelled Manica Carcano. Manica Carcano can hit a thick wrist bone, as the Warren Commission demonstrated, and it only becomes blunted on the nose. It keeps going. It doesn't break up. It just gets nose smashed. This skull bone in the back is thinner than a cadaver wrist, and would never, no Manica Carcano in history has ever crumbled and disintegrated like this bullet had on entry, merely on a thin skull bone in the rear. And even more than that, the HSCA panel found out that that bullet started to break up on contact with the skin. It threw off particles of the bullet outside the skull and in the skin, under the skin, which the autopsy doctors never knew because they weren't using the x-rays, so they were completely blind on this. But that fragment pattern called a lead snowstorm that you saw going through the skull the last 2 days is the classic textbook definition of a soft-nosed bullet. And I guarantee you if we got Mr. Haig up here and asked him that, he would admit it. No Manica Carcano, having hit only one thin bone, will start to disintegrate that and leave that cylindrical to slightly conical pattern of jacket and lead core bullet fragments as it goes to the exit. And there were even tiny fragments embedded in the exit hole area, around the exit hole, that smashed into it there too. So this was not a Mannlicher Carcano, it was a soft nose or hollow point bullet. And you see the front x-ray, this round disc with the HSCA panel found to be a 6.5 millimeter circular disc. You can see it has pretty much machine smooth edges, almost a perfect circle, although slightly bent from the impact. And then, then this one up here is part of the side of the jacket that was thrown up outside the skull again. So I say in my report, these are two of the most important pieces of evidence in the entire case. If the autopsy doctors had used the x-rays and seen this and dug those things out, we would see that this is a base of a soft-nosed bullet. A Mannlicher Carcano has no base. It's open at the bottom. It has lead poured into it from there. The soft nose is poured in from the top of the lead, so the base is a solid 6.5 millimeter piece of copper if it's that caliber. And that's what they use, the same caliber here. Here's the Warren Commission head path. They had the entrance 4 inches too low because the autopsy doctors correctly isolated the oval hole you saw in the cowlick. But as the autopsy went on, they let the hair flop over it after they photographed it and measured it. And later on, a piece of tissue down 4 inches lower was what they used as the location of the head wound. The autopsy doctors admitted that error many years later. So here's what the Warren Commission would like you to believe is the trajectory of the head shot. Now, the Fox animator has moved the sheet of paper over to bring that head upright. As you can see, if you turn the sheet of paper correctly, they have him looking down at his navel, which you saw 312. He wasn't looking nearly that low at that point. She turned the paper straight up, but I would tilt it forward a little bit because we saw his head is bowed a little at that 312 point. So I would have the actual trajectory once you bow that head a little about along here, which still has the shot coming from the trunk of the limousine. And if Oswald had fired that shot, as I said, he's always right to left, shooting down from the 6th floor right to left. Here's what that shot would have looked like had he fired it. Okay, goes in the cowlick, center of the back of the head. Now the president's head is slightly tilted to the left, not directly center with the limousine, slightly to the left, so that small right to left angle at this distance from Oswald goes right through the middle of the slightly turned head, would come out in the forehead as this animation shows, and would have hit Governor Connolly in the neck. Didn't happen.
Or is that his wife? Or is
That's Governor Connolly.
Okay.
His wife's not shown. She's
Okay.
sitting. She's holding him up. Now, there was a fourth shot. James Tague came forward very quickly, and the Warren Commission finally listened to what he had to say, and he was standing right here, and a bullet hit the curb of Main Street and grazed it. I've examined and photographed that piece of curb, and I see the deflection mark, which is the right angle of deflection, and it came up and hit him in the cheek. That bullet was never found. There's nothing in the record that anybody ever looked for it. They knew Tague had been hit by a bullet or bullet fragment, and apparently nobody bothered to look for it, so we don't know where that bullet is or what it was, but presumably that was Oswald's third shot, since we've just shown you that the head shot was not his third shot. So here's the photograph of the curb mark, and the FBI found lead in that mark there, so we know that's what it was from. And this is Tague's cheek with the grazing injury. In April 1995, I submitted my 66-page report, this title, to Attorney General Reno's office. A couple of months later, I first met with the DOJ attorney assigned to the matter, And during the almost 5 years before this matter was finally closed, no one from DOJ or the FBI ever engaged in any kind of dialogue with me or questioned me or challenged me on any of the many facts of my conclusion or conclusions of my report. They treated it like a dead, rotten, stinking fish. They just wanted to go away. The DOJ attorney assigned to the matter made it clear to me that a 31-year-old murder case was the lowest priority in his inbox and remained that way. January 25, 96, the Criminal Division finally requested the FBI to examine and test certain of the bullet fragments, including a fragment which, with several types of foreign matter adhering to it that I noted in my report had never been tested. DOJ recommended that I be detailed to work with the FBI on the project because of my extensive research and knowledge. The FBI refused to have any contact with me, saying I had a conflict of interest, having already reached my conclusions. In January 2000, the results of the FBI testing were released, and they were spectacularly uninformative. Although several types of foreign matter were noted on the bullet fragment, they chose to test only 2 types that appeared to the naked eye to be organic. They were determined to be human skin and human muscle tissue. DNA tests were run and were inconclusive. Richard III died in the 1400s. They dug him up from a parking lot in England and got DNA off of him. Couldn't get DNA off of 1963 samples that had been meticulously preserved in the archives. The FBI said I had a conflict of interest, but my only goal has always been to learn the truth. However, in my opinion, this investigation never should have been turned over to the FBI. It was, in effect, DOJ saying to them, please take a look at this evidence and let us know whether the FBI badly botched the original investigation into the crime of the 20th century. I think we all know what that answer is going to be. Any future examination of the JFK evidence should be done by investigators who have no institutional interest in the outcome and by experts who have no special knowledge of the assassination, have not publicly stated their opinions about it, very important, and preferably were not even born in 1963. Now, this is an ethics presentation. Doesn't sound like it, but everything I've said relates to something that we're going to talk about now. The Code of Federal Regulations, which controls the FBI and the DOJ employees, controlled me when I was there, and is specifically incorporated into the FBI Ethics Guide, says that unless authorized under no employee shall participate in a criminal investigation or prosecution if he has a personal or political relationship with any person or organization which he knows has a specific and substantial interest that would be directly affected by the outcome of the investigation or prosecution. I would submit that the FBI would fit into that organizational definition.
Why is that?
Because they staked their reputation some years ago on having gotten that right, and if it's proved that they missed it, it was so obvious, and they missed it badly, then when they go into court and testify as to other crimes, their reputation will be diminished substantially. And having been in the Department of Justice my whole career, I know that government agencies do not work for a profit. They're not business enterprises. Their sole thing is their mission, and their mission is protected by their reputation. And you guard that reputation zealously and hopefully ethically, but if that reputation is hurt, your mission is badly damaged.
In the Manders of the world, the criminal lawyers would be using this to question FBI.
Exactly. ABA standards of prosecutorial investigations. The prosecutor should resist political pressure intended to influence the conduct, focus, duration, or outcome of a criminal investigation. The prosecutor should generally not make decisions related to a criminal investigation based upon their impact on the political process. Kind of goes back to the Warren Commission, doesn't it? So those are the ethical issues that I see that are brought in by what I ran into. I do not see a grand conspiracy to hundreds of people in the whole military-industrial complex and the Justice Department trying to alter evidence. I see bad mistakes made, people acting under grief and shock, making errors, people hiding secrets unrelated to the assassination that make them look suspicious. But as I said, my analysis I've just showed you is based entirely on evidence in the official record. Everything fit together perfectly. I didn't have to find that somebody had jimmied an x-ray or something, because the x-ray fit the straight line. You wouldn't be able to alter something and know how to alter it to make it look like you want it to.
So I have a question. I know that you're unwilling to identify the person Are you aware of an organization potentially behind this person?
At great risk to my own life, I will say the mafia did it. My research was limited to Dealey Plaza and what happened there. But in doing that, you have to read thousands of pages to get to those tidbits. So I feel like I know a lot about what happened in the background of this, and I am convinced that the mafia did it, as was the House Select Committee in 1979.
So let me indulge me for a second, because I know people are going to, at least I know many people will be interested in the next question. If that's the case, why would the mafia take a chance at shooting a president, knowing that the next president might, his brother, the dead president's brother is still Attorney General, and why would they think this would solve their problem?
I don't want to get too much into politics here, but this person who did it was a criminal genius, and he executed it very well. It's been 54 years, and he got his goal. Robert Kennedy was engaging in the most effective war against organized crime that ever has been. Maybe Rudy Giuliani would dispute that, but at the time, Robert Kennedy was on the way to wiping out the mafia, and they could not afford, and the person who I believe in the mafia who was behind this ultimately hated Bobby Kennedy with a purple passion, and he had personal reasons to do it, but institutionally, they had to stop Bobby Kennedy's war on organized crime, and killing the president, as this person said, you kill the head of the dog, don't cut off the tail. So it was spectacularly successful because the day of the assassination, Robert Kennedy was neutralized and the war on organized crime ended that day.
Okay. Dr. Weck, you're the...
Sure, how are you, sir? Nice
Good to see you again. We were on camera together.
Yes, we had a wonderful time in New York, although Peter Russo did not take us to one of those fancy New York restaurants, did he?
I won't let him. I won't let him.
Mr. Orr, going with your scenario completely, for the moment, then, what is the relationship between this unidentified, unidentified to us, mafia figure from the records building and Oswald as two shooters? How did that?
There is a direct 1 or 2 degrees of separation without getting into any detail. I found in my research that all roads out of Dealey Plaza lead back to the mafia. And I'll go ahead and say one name. Carlos Marcello was the brains behind this organization, as the HSCA ultimately, I think, concluded without indicting him. All the evidence indicates to me that he was the planner. He was extremely skillful at this. He knew how to manipulate people, and he used Oswald as the one, going back to Sicily, when you kill a political figure, you know that somebody will have to be nailed. They will not go away, the public, until they get an answer. So you deliver up, under the old mafia plan in Sicily, you deliver up a patsy. This was not an innocent patsy. This was probably an unwillingly recruited patsy, Oswald, who had to participate or die at the hands of the mafia. So he is the one who's leaving all the evidence, all the breadcrumbs, so that when he safely gets out of Dallas that day, everything will lead to him, but he can't be found. He'll turn up in Mexico or South America, somebody will see him there, he'll never be seen again. But Tippit messed all that up. If it hadn't been for Tippit, Marcello would have been drinking champagne all night long.
Bob, you want to?
I don't know.
Go ahead.
Well, I think Cyril kind of hit on one stumbling block for me anyway, and just one person, I could certainly be wrong, is that, you know, anybody is, I believe Oswald was shooting from the 6th floor as well. Okay. One stumbling block I have is the notion that anybody in cahoots with Oswald, especially another shooter, there presumably would have been some planning. There presumably would have been some contacts. And we all know that you just mentioned the mafia was involved in this. We know that since the late 50s, the FBI had been monitoring, you know, national mafia communications. It seems to be pretty risky to sign on to a plan with a gun that has to leave his easily traceable assassination weapon behind his floor. Obviously, he couldn't carry it out of the building with him. He dropped it there because he had to. It seems, I can't get beyond the notion that somebody would risk identification by association with Lee Harvey Oswald. I guess that's the bottom line.
Well, that was a risk, because Oswald grew up in the penumbra of the Marcello organization. You probably read all his uncle.
I'm going to get in cahoots with Lee and have him shoot. And you know, I have to presume, especially since he's high profile to the government, we've
Right.
heard that, you know, he's in Mexico City. I mean, the government had a dossier on him, etc. I buy all that. I think it's all true, and it seems to me that the last thing I would want to do is to be in a planning operation with Lee Harvey Oswald, knowing that he's going to be identified within 24 hours of the assassination, and they're going to come looking for me immediately.
Well, the posit to that would be, I think, that this person was aware of the intelligence curiosity about Oswald, and that this guy is walking around and he's, you know, I think if someone was aware that the government was going to not fully investigate this, and John and I have talked about, I'm not sure if you want to talk about it publicly.
Go ahead.
And then the other thing is, it seems to me that this was probably one of these, you know, risk-benefit analysis, and probably they were very desperate. And if you're about to get
No, I agree with that risk-benefit analysis. I just think that the scales are.
Yeah. Well, if you're about to go extinct,
that's just a
right,
judgment. I
right.
mean, different people can make.
I think if you're really desperate, you're probably going to say, okay, there's a 90. Yeah.
I mean, I think your point about, you know, what would they accomplish with this ultimately, other than vengeance, and I know that I don't know much.
And that might be part of it
itself
also.
Other than what I've read, but if you get past vengeance and you start talking about somebody with a sense of rationality,
and you may not.
There's got to be more than vengeance then, and that's kind of where I come down. I could be wrong, but that's where I come down. I just have a whole lot of trouble thinking that somebody would have planned the event with it.
You raise a good point, and both shooters, according to my analysis, had about second-degree separation from Marcello. So he had a little protection, but there was a big risk there. But all I can answer is 54 years later, he hasn't been charged. He got away with it. So he must have done something right.
Tink, you had a question.
Yeah. I find this
And then we
a
have to-
ridiculous, very extremely original. Microphone. I find this quite a piece of work.
In a good way. In a good way, right?
A marvelous piece of work, really.
Thank you.
And I have a question of clarification with regard to one point shown on the comparison of slides between 312 and 313. You mentioned that Connolly's wrist was hit at that point and could be seen to move forward. When I looked at it, I saw a vertical line between what was Connolly's head, I take it, and his wrist and shirt. I didn't find that lower glint to move forward that much. Could you go back to the slide and let's look at it together?
try.
Maybe you can educate me.
So you can see why, after I spoke to John, I felt this was, we couldn't get him in the mock trial for a variety of reasons. We already had done the schedule, but this is fascinating stuff.
Right.
I think, to fully answer your question...
Could you point out first with your
I have a pointer here.
Is this it?
It's hard for me to see this close, but...
So you have Connolly's
you can see
forehead
his cuff
first.
right there. Clearly the white cuff right there, and his hand is kind of cocked. It's
Okay.
coming up pretty sharply and then cocked back down to hold the Stetson.
Okay, and the forehead is...
And this is relatively flat. The hand you see to me looks very flat here.
Well,
And obviously, we're at a disadvantage. If we had the really high resolution right in front of us, we could see it pretty clearly. But, and this was agreed with by the Warren Commission attorney who wrote that. He saw the same thing. So I'm just agreeing with him that...
And that's his forehead that we determined the right, that this is Connolly's forehead above, directly above those points?
Yeah.
Okay.
Yeah, well, the measurements that I've read were about 6 inches forward, and that's mainly going with the tie and the hand from being cocked like this to going kind of flattened out and the Stetson disappearing down below. So, you know, it's arguable how much it moved, but I agree with the Warren Commission attorney that it moved too fast to be voluntarily an 18th of a
Well,
second.
the caveat that I'd like to throw in here is that I think I made one dreadful mistake back in 1966 and 67, and that was that I claimed to have measured the movement of the president's head between 312 and 313. That turned out to be a very significant mistake. What had actually happened was that since 312 is extremely clear, and 313 is blurred, that blur introduced what I measured as a movement on Kennedy's part. What it actually was the movement of Zapruder's camera. He was startled at that time by the shot.
Well, as I told you last night, I used that chart in my report, and I agree with your original determination, and the House Select Committee photographic experts agree with it, that his head did move slightly forward at the impact from the back of the head because of the drilling impact of the bullet. The pristine bullet knocked the head forward slightly, and then this huge explosion of matter, like a jet engine, created the jet recoil effect and blew backwards. But I want to say, while I have a chance, I told you, I went to a collector's bookstore and bought your book, and that was the first basis of my research, because you were the only person who did detailed research with the bad information you had to work with from the Warren Commission. But you did a great...
Still remains the best book out there.
You did a great job of getting me started. I never would have even been able to get off the ground without your book, and I thank you for that. But back to the point.
We got time for one more question, that's it.
Back to the point, the head goes forward and to the right. This is all the left to right momentum, opposite Oswald. Goes forward to the right from the modest momentum of the bullet, and then violently back to the left. And as Mr. Hakes said, the head goes back toward the shooter. The shooter is back left. That's where the head goes, and the County Records Building Annex is back left.
But last question.
Mr. Orr, briefly, what about the grassy knoll, the circumstances where the policemen and the people were going down the grassy knoll? You can do it. Oh, you can do it from here. Number one. Okay. Number two, I gotta get the if Oswald was so erratic, why would the mafia use someone like that to carry out the killing of the president?
Because he was a patsy. Number two was the guy who can hit a silver dollar at 100 yards. He's the killer. This guy's just drawing attention. But back to your other question, kind of a complex answer. There's no question that it sounded like the shots came from the grassy knoll, but there's a lot of research on that. The echoes all over the overpass, everywhere, echoing shots in that kind of closed environment. So yes, it did sound like the shots came from there. That's why a lot of people ran up there. Yes, there were apparently people with phony Secret Service credentials turning people away up there. Yes, 2 people said they saw a man with a rifle leaving from behind the stockade fence. Yes, there was a puff of smoke up there probably, but there were cigarette butts right in the corner. Somebody was standing there smoking cigarettes. So my conclusion on that was that there very likely was a third shooter there for a last resort shot right down into the limousine at close range. And make no mistake, that shot would have been sideways. It would have probably hit Jackie when it came out his head. So that shot never happened. There was very likely and possibly a shooter there who was not necessary once that head exploded at 312.
And there could have been a spotter with binoculars.
We have to cut it off. You could talk to him privately.
Could have been a spotter, yeah.
So, John, I want to thank you very much for your very informative. John, is this your computer? Okay. And by the way, if you, Howard Willens? Yes.
Can I say one more thing?
Sure.
My entire report is in your CLE materials.
We uploaded
it's also online. My last slide has the address online. Where you can
Here, John.
Great job.
John.
Great job.
The journal and the memos in Howard Willens, he wrote his book, History Will Prove Us Right, and he had a website with these memos, and you could glean, if you know how to read the lawyery writing, you could see the disputes amongst the legal staff about some of these questions. He doesn't come out and quite and say it's a dispute, but you can read, by reading between the lines, you can see that the staff was very uncomfortable the first couple of months, and then finally get the message to follow the warrant, the Chief Justice.
Howard Willens wrote an article in the American Spectator. I don't know if you ever saw that.
Yes.
I published a letter of rebuttal in there. It was the longest letter they've ever published. You know,
Great.
That seems to be a rolling legend.
Judge, Jay, you're going to do...
I'm going to talk a little bit about this stuff and Michael Morton, et cetera, while you're setting that up. Criminal justice and criminal justice techniques have changed dramatically in the last 20, 30 years, and especially in the last 5 years in the state of Texas. And what I'm going to start talking about, and by the way, this is just, I was asked yesterday or day before yesterday if I would help with this, and I'm happy to do it. And I'm just kind of speaking off the cuff, but this is very important to talk about. Article 3914 in the Code of Criminal Procedure governs discovery in the state of Texas. And based upon recent events within the last 5, 6, 7 years of convictions of individuals who were not guilty but were convicted with despite the fact that the defense that they had was not given evidence that was withheld by prosecution and prosecuting authorities. And the most famous of them is the story of Michael Morton, who was a guy that was convicted out of Williamson County like 30 years ago for the murder of his wife. And Michael Morton sat in prison for 25 or 26 years before he was released, and the release was after about 2 or 3 years of writ of habeas corpus evidentiary proceedings in Williamson County to try to get the evidence that was never turned over to his original trial counsel. And I'm going to read a little bit about what happened with that. He was wrongfully imprisoned for 25 years for his wife Christine's murder because prosecutors withheld exculpatory Brady evidence, a bloody bandana found at the crime scene. And this bandana was found about 100 to 150 feet away from the house near a wooded area, but was never turned over in response to discovery requests by his lawyers. Yes.
A question from a juror.
We have a question from the jury.
Yes.
What is the question?
Okay, what's the question?
They ask if they could come ask a question to the judge.
Well,
should I bring them down? Or just
well, I'm not going to, I mean, just tell them to do the best they can, because we can get into questions and that can go on for hours.
Okay.
So tell them to please continue your deliberations, and if they reach an impasse, to let us know and we'll come back, okay? So later testing of this bandana revealed that the blood belonged to a person named Mark Allen Norwood, who was convicted for a different murder in 2013. And two years after killing Christine Morton, Norwood murdered Deborah Baker, a mother of 2, under very similar circumstances, and it was his DNA that was found on that bloody bandana, and Morton was released. Michael Morton then went to the Texas legislature and lobbied, along with the Texas Criminal Defense Lawyers Association and others interested in reforming the discovery process in Texas, to tighten up discovery, production, and documentation in Texas. And now under Article 3914, which is considerably rewritten, the state of Texas is under an affirmative duty to tender to defense counsel upon proper notice, it's written notice, all of the evidence the state intends to rely on, as well as Brady evidence, and there has to be a very specific documentation process done, and that is now the law in Texas. So hopefully Michael Morton's won't happen. There are a couple of other cases that I can't remember the names, but that's happened in those cases as well. So now the state of Texas really has to give it all over. And there's been a practice in Texas for many years. I mean, when I was in the DA's office in the early 80s, it was a common practice in Harris County to have an open file and allow the defense attorney to take notes, make copies of certain things, even parts of police reports in order to satisfy discovery requirements. But some counties in Texas wouldn't do that. They would just say, file your motion, and there would be this cat and mouse game of, I'll give you this, and then they'd press a little more, I'll give you that, and well, let's go talk to the judge because I've heard such and such, and they get in front of a judge on the record, and it was just teasing out of evidence that happens a lot in smaller counties. And I'll be frank with you, it happened in a few cases in Harris County and some of the larger counties where the prosecutors didn't want to have an open file, and they would press on a few cases, and the typically high-profile cases. But most of the cases, they had an open file. Michael Morton now requires documentation, all of that. It's a great law, and it's still evolving, but it's a good thing. Now, with regard to identifications, the typical way identifications occurs, a detective will call a witness in to a room, and they'll put together what's called a photo array, or what's also known as a photo spread. And they're pictures of, you know, the main suspect and 5 other people that are supposed to be similar in appearance. And the photo array is typically put together by the investigating detective. Well, ABA guidelines and also guidelines by people who are experts in criminal investigation counsel that the photo array or any showing of photos should be done by an independent police officer that's not involved in the investigation, and that the photos should be shown to the witness one photo at a time rather than in a series or an array of photos. And I don't know that HPD or any of the Harris County agencies are doing that yet. They're still showing photo arrays, but there's a movement afoot to try to get the identification process more in line with best business practices or best law enforcement practices. But that's another area. And we were talking about eyewitness identification earlier. One of the last cases I handled as a criminal defense lawyer before I became a recovering lawyer as a judge involved eyewitness identification in a rape case and in 2 robbery cases. And I was one of the first lawyers in Harris County to use an expert witness to attack the reliability of an eyewitness, particularly in a cross-racial crime. And I had long Daubert hearings in both cases. In one case, my expert was allowed to testify, and the other case it wasn't, but I was able to make the argument in front of the jury in all 3 cases. In 2 cases, I got acquittals, and 1 I got a dismissal. And again, eyewitness is a very, very crazy area. People say, oh, they point to the person, he did it. Not necessarily the most accurate. In fact, probably the least accurate. And so you're seeing police officers now more and more corroborating eyewitness. It used to be in the old days, once they had the eyewitness, case closed, that would be the end of the investigation. It really should be the beginning of the investigation, and have the law enforcement look at other supporting facts supporting the eyewitness identification. So that's about all I have to say about the history of these procedures.
What you're going to see is an...
Question.
Why, okay, why one at a time pick the photos instead of interacting?
Yes, Catherine, are you raising your hand? The theory behind it is to have the witness look at a picture and say, is this the person or not? Yes or no? And they say, no, that's not the person. So that photo won't be shown to the person again. And then sometimes the witness will go, I think so, but I'm not sure. And they may come back to that later. And then they keep showing photos of other people, you know, that might be, you know, that fit the description. And usually the description is given orally or verbally by the individual. 5'5" in height, blue eyes, brown hair, white beard, you know, etc. And then they try to find, you know, photographs in the suspect photos, and they look for these photos, and they have like libraries of these photographs, and then go one at a time and show them. So the studies show that it's a more accurate way for the witness to focus on this one photo without steering them. And also in the past, a very interested detective trying to close his or her case might show the photo spread on there and put their thumb on the photo of the one that they want them to pick, and there are very subtle ways that somebody can show a photo spread and get the witness to pick the picture. I'm not saying that all police officers do this, but I'm just saying there's a potential for that to be done, and so the way to prevent that is to have a disinterested from the investigation officer showing the photographs in the process of trying to get an identification. It's just a cleaner way to do it, according to all the studies and according to the ABA guidelines on recommendations for changes to the system. That's why.
So the lineup in the Oswald lineup was.
Well, this is what we're going to go over. So this is an excerpt from Burt Griffin, who is a senior judge in the Federal District Court in Ohio, but he's also a former staff attorney on the Warren Commission. And so we're going to have Jay and I can have a little tag team here, and Amanda could step in as well. Kind of just go over the chronology of Oswald and how his rights were handled then compared to now. So this is Commission statement about Oswald not being subjected to any coercion, and he was advised by his rights. And then this is Captain Fritz, who was notorious for getting confessions. Not very good at detailing police work, but apparently very good at getting confessions. And this is, or for the lawyers in the room, we're going to blow through this because actually the jury's going to be coming down in a few minutes. This is, this 1963 was before the Miranda decision. Lawyers, this is just a quick review here. Voluntariness standard. Then 64 is kind of the magical time we have. And then we have the Malloy decision that applied the Fifth Amendment to states. Messiah, I'm getting out of my regime now. Escobedo, and then he's requesting you have an opportunity to request counsel. He needs to get it.
And notice the votes on these decisions. They're 5-4.
Wow. Yeah.
Okay.
Wow. This is during the Warren Court.
Yeah. So reasonable, good decisions barely sneak by.
Yeah, yeah. And there's some question about whether Burt Griffin in his original presentation had a slide about did the Warren Commission experience affect some of these decisions. But I didn't hear his presentation because the Case Western didn't put that online. We have the Miranda decision in '66, so here's Oswald. And this is his first statement. This is in the Texas Theater. Well, it's all over now. And this is a voluntary statement, so presumably not subject to Miranda.
And by the way, under Texas law, Miranda is triggered when somebody's in custody and they're interrogated. When they're not in custody, and there's a whole body of law, your jury can come in, there's a whole body of law that defines when somebody's in custody.
The juries come in?
They're free to leave, whether they subjectively feel that they're free to leave, and there's a whole argument that's done on whether someone's in custody, and it has to be interrogation. So somebody's sitting in the police car saying, you know what, you guys got me, I did it. That's not interrogation. That's not a confession. That is just a statement against interest by somebody who happens to be sitting in the back of a police car.
And that would be admissible?
That would be absolutely admissible. Not when a defendant, even in custody, makes a statement not in response to custodial interrogation, that comes in. Absolutely.
So,
it is admissible.
So we want to interrupt the ethics presentation for the jury to give its verdict, and then we'll let them leave so they can beat the traffic, and then we'll continue our ethics presentation. So,
let the record reflect that the jury has returned to the courtroom. All are seated. Counsel is present. The defendant
That's risen.
is risen. Okay. Okay. And I asked, has the jury reached a verdict? Yes or no? Yes, sir. And who is the presiding juror? Would you please hand the verdict to me and I'll read it in open court?
You're going to be mad.
Okay. We have a hung jury. We have 6 of, and I'm not going to identify which decided which, but 6 decided guilty and 5 decided not guilty. And 1 is missing. 1 had to leave because of an emergency, I believe. Is that right, or?
No, she didn't come.
She was unable to make it today. So that's the split, folks. And
no winners and no losers.
no losers.
We just lost the audio feed. I don't know how that is. Well, there you have it. Or you don't have it. Hung jury. And I guess that will lead to more and more speculation and I guess maybe the defense can do a better job next time and learn what they did wrong and make a shorter, more concise presentation of facts. And we'll discuss that on Black Op Radio coming up for this week's show. Quite frankly, I wasn't convinced either way which way it was going to go. I didn't feel really confident. And there was a lot presented there to exonerate him, especially a second shooter. I don't know how you can have two shooters and still think Lee Oswald shot anything after all you've heard. But, crap. It's, we've lost our audio stream again. Well, I'm going to try one last time to see if I can get anything other summations, but I just see people kind of standing up there. So hang on. Let me see if I can go trials on break. No, that's not it. Please stand by. Hang on a moment.
And who is the presiding juror? Would you please hand the verdict to me and I'll read it in open court?
Okay, I backed it up so we didn't lose anything. Here we go.
You're going to be mad.
Okay. We have a hung jury. We have 6 of, and I'm not going to identify which decided which, but 6 decided guilty and 5 decided not guilty. And 1 is missing. One had to leave because of an emergency, I believe. Is that right? Or?
No, she didn't come today.
She was unable to make it today. So that's the split, folks. And
So no winners and no losers.
no losers. As promised, no winners, no losers. The members of the jury, on behalf of South Texas College of Law, my alma mater, and a school that I taught as an adjunct professor for 10 years, criminal trial advocacy, and on behalf of the fine lawyers and the folks helping the legal team and the witnesses and all the experts that came from hither, thither, and yon to come here and give us your knowledge and thoughts about this case. We all thank you for your service to this project. You're welcome to stay, but you are also welcome to leave now. You have given us 2 full days of your life, and we so appreciate it. Please give them a hand, everybody. Let's give the jury a moment to leave if they wish, and then I want to get back into this discussion. We're going to go to about 4:45. Is that enough? And then we're going to call it a day.
Oh, okay, thank you.
Thank you. I'll be by Warren soon.
Actually, I started a new job. I know everybody.
Awesome, thank you.
It's like the Astros and the Yankees. I lost again.
Yes, sir. Thank you very much. I was enjoying Yeah, I'm going to hear about it tonight for sure. Thank you very much. I have your card. And I will definitely look you up when I get there, for sure. Yes, sir. Thank you.
Okay, so
I want to add one more thing to Gus. Are you leaving, Gus?
I really do need to.
Understood. Thank you very much. This is Gus Pappas and his team. Would you introduce your team, Gus, to everybody, please?
Sure. Your Honor, one statement for the record, for the record, sir.
Yes, sir, you may.
statement, the attack on Dr. Gary Aguilar as an ophthalmologist, a name that was mentioned, I would like to have a $100 bill in my wallet now every time by the prosecution, but Latimer is a urologist. So between a piss specialist and an eye specialist, I think I go for the eye.
Well, you know what kind of contest I think this sounds like, okay? All right. Gus, would you introduce your team real quickly, because I know you have to leave. Go ahead.
Sure. This is Nicole. Nicole is an associate in my law firm, and she's been with me 10, 15 years, and she's been a sidekick in trying cases. And then Nicole says her greatest attribute to the whole thing was bringing Amanda. And Amanda, we're all three graduates here from South Texas, and Amanda has been a prosecutor as well as now as a criminal defense lawyer, and she did a fabulous job in this thing, and I really hope you all appreciate all the work that she did.
And I want to add that what Gus and his team had to confront was 3 attorneys who knew this, who've been involved with this case for 30 years at least, sometimes up to 50 years. And when Gus and Bill and I had our first conversation, Gus did not know anything about this case except that his father saw John Kennedy the night before the assassination. So the amount of learning that they did, they did an incredible job. I mean, in a couple of months and probably actually a couple of weeks. Right. So I just want to say this team is an excellent legal team. If ever you need a trial attorney, this is the guys to use. And Amanda too. Thank you.
Actually, I intend to submit Gus's name as a special prosecutor for the big fees that y'all are fussing over getting right now. But you would make a great special prosecutor, Gus. That's my opinion. Thank you.
Thank you, Judge. And I also want to thank you very much for all your kind words and your help and your assistance in this process and your wonderful touch and judicial demeanor in this particular case. And also, Larry, you've been a true gentleman throughout this whole process, and I very much, and Bill, the same. I very much have enjoyed our interplay and our discourse, and it won't be forgotten. And also want to thank Bob Wagner here. Bob came here voluntarily for the last 4 or 5 days, and y'all saw his book at the beginning, and really enjoyed meeting him. I think that that's the greatest part of all of these sorts of things is that we get to meet fine people, and
we made new friends.
In any event, I've enjoyed, and I apologize if at any point in time I was a bit overbearing in the cross-examination, but I've enjoyed meeting you, Dr. Aguilar.
Well, there you have it.
Well,
there you have it.
Thomas.
I've heard people are taking down on homage to the LA riots. People are down in Dealey Plaza. It's a riot going on. They're overturning cars. They're burning police cars. There's rioting going on. No, that sounds funny. All right, well, that's about all I'm going to put up there for today. Dedicated 2 days to get this out there, so I hope people appreciate it, and I think they do. So thanks for tuning in, and of course we'll be talking about this and the trial and the results, and we'll learn from it. So next time somebody has we think about this, presenting it, I think Cap has got some things in mind, but they're going to have to be a little more on the ball and get right to the point. But it's very interesting to see their tactics. These people are working for free. So I had a few people complaining, what are these guys doing? What are they doing? Well, they're doing the best they can for something they think about, and they're volunteering their time. And in this case, this was their best, and it was a hung jury. And since there was one juror missing, we could assume it was 6-all. 6 people heard all this and still voted that he was guilty. So they didn't present their case definitely enough, with enough proof. Although it's a long, tedious case. Those of us looking into it have spent years reading and looking into evidence. So I don't know. I thought Oliver Stone's movie did a pretty good job doing it in 2 hours. So, all right, stay tuned to BlackOpRadio. Thanks for listening to the live broadcast. And I'm sure the video of this will be available from Kappa. Randy Benson down there in Houston making this. And if you have any other comments, questions, whatever, send me an email, at BlackOpRadio then. Osanik@prody.org. All right. Thanks, everybody.